permission to mention my matter. It is already in the monthly serial list in 1104, Your Lordship.
Mentioning is only on Monday. Every day.
Yesterday it was a no adverse. That's why I didn't prefer. It was a no adverse at 10:30 yesterday due to a resolution.
Many advocates mentioned yesterday.
I heard later, but and also I stay far away.
Right, hand over the slip.
Hand over.
Hand over the slip.
My lord, yesterday I mentioned matter 2286. Tomorrow is the date for final hearing. Can be
Tomorrow, who has mentioned, please don't mention again because the.
My lord, yesterday
I mentioned it.
My lord, yesterday matter was moved, my lord. I submitted before this court that the next date is fixed on 31st of July because that was there in the case status of the e-courts. In the evening, my lord, it was found out that the last order was uploaded and the case status has been changed. Now the next date is fixed on 28th of August. I find, my lord, the order has not yet been, my lord, uploaded on the server, my lord. The lordship's order, yesterday's order. So I made a, my lord, incorrect submission.
All right.
If we can accommodate it under the to be mentioned, my lord.
Lord, I am constant to mention this matter. My lordship kindly legal one of the matter which a incomplete certified copy on the basis of my lord's call for after report. My lord ascertained. My lord wanted to decide the matter on the next day. Now, my lord, on 8th it was due to appear. Now it is appearing in item number 1.
Please hand over the slip. Yes.
May
Mention that fact. Mention that fact. Please hand over the slip.
But in my case, a due date has fixed by this honorable.
Mr. Rai, have you mentioned that fact, that certified copy, that matter?
Yes, I have given the order of the honorable court. My lord's order have annexed.
Please indicate that in the urgency. Please indicate that.
In my case, a due date has fixed by this honorable court, but matter has not twisted. But in my case, I being the widow, deprived of all the benefits of my husband, as because the
It's appearing in the list.
it is in the monthly list, my lord.
Please hand over the slip. Mention the urgency.
My lord, I am mentioning this matter under extreme compelling circumstances, my lord. My lord, there are 2 checks of 1 crore rupees that has been given, my lord, that is maturing on the 20th of July. My lord, that is under an agreement which was signed when I was in jail, my lord. I'm an old and ailing person, my lord. I'm a senior citizen. My lord,
What do you want? Upgradation?
early hearing, my lord. It is item number 311, your lordship.
My lord, my evidence will be closed, my lord. Several times I mentioned and paid time for the trial court.
Please hand over the slip. Yes.
I'm paying for upgradation, my lord.
Upgradation, please.
Lordship, I am petitioner in person. I am mentioning my
Upgradation.
yes new motion.
Yes, Mr. Rai.
Is for filing without the certificate copy. I'll get the certificate on Friday. Date has been fixed with the court below on 21st. So I want to file it before moving the same on Friday. Before Friday, my lord, I'll file the certificate copy.
My lord, may I be permitted to mention?
You have the server copy.
Yes, server copy I have annexed, but I'll get the certificate on Friday.
My lord, may I
It
be
has been
permitted?
fixed on Monday. That is why I.
Yes.
May I permit to mention one item? We combined 1152.
Upgradation.
No. I am paying my body full mashal. Can release it otherwise.
Item number
1152.
1152. Kalke 2 mentioned.
My lord, may I be permitted to mention one matter, my lord? Yesterday, my lord had granted a leave to file this matter without the certified copy, but with the typed copy of the gist of the 2 orders. Mr. Kushal Chatterjee had mentioned this matter. Only one thing, my lord, the date that has been written here for the date of the leave is granted as on date 13/7/2026. My lord, the filing section will not accept this matter, accept this because of it is of previous date, my lord.
This is a matter, my lord, which has been fixed on 17th of July.
What do you want? Upgradation?
No, my lord, it was already in the list. Suddenly, my lord, I do not know. The matter has been made out. 17th July is the next.
In a very urgent matter, in an earlier
Upgradation.
early hearing. Lordship,
Hand over the slip. Yes.
Extension of interest, my lord. Extension of interest.
My lord.
When it is expiring, have you indicated that? Already expired. Yes, call the list.
The 17th is the date, my lord.
Yes.
My lord, may I be permitted to mention a matter for upgradation? In a suit for eviction, my lord, order 1.
What is the impugned order?
My lord, in a suit for eviction, my lord, the tenants paid for section 151C of the suit because there are 2 sets of landlords. So to avoid that confusion, my lord.
Yes.
I am paying objection of this matter due to the urgency.
Hand over the slip. Hand over the slip. Indicate the urgency. Yes, Mr. Chakravarti. Yes, call the list. Lord, my lord wanted us to come back with instructions in that
Your lordship
consumer
kept
dispute
this matter under the heading to be mentioned as to Milord, whether
Lord,
the parties
yes,
can
yes,
Milord,
Lord,
hearing was concluded.
let me,
Last
since I am for the petitioner, may I say this, Lord?
Just informing the
No,
court
no,
that
don't.
last evening Mr. Chakraborty informed
Mr.
that
Mukherjee
his
is now hijacking proceedings from the petitioners, my lord. I don't know
What
how,
can be done in your
A
company?
poor,
He's
poor
in your
lawyer.
company now.
Well, I'm just informing.
I don't want to say anything else on that, Lord.
Yes,
Lord, yes, I told them, I called him yesterday. I have somehow exercising my Lord limited authority. I have Lord made them agree to one proposal, which I feel reasonable. They may not feel. Flat will be.
Have you indicated it?
I
to
have
him?
indicated to him the flat will be registered. The agreement says open covered car parking space. We shall give a car parking. Only we said that since the dispute that we did not receive money, today the market price is 5 lakhs. If they pay 2.5 lakhs, not half of the amount, we'll give them registered any day what they want. That will shorten the litigation. And if the litigation continues, ultimately both of us will end up paying that amount. Ultimately, Supreme Court commission, this and that. I told, I think
The
it would
client
be
agreeable.
I conveyed, Milord, through my learned advocate on record. The client instruction is that in 2003 itself, whatever the sale consideration entirety was given. And by this passage of Milord 2 decades, this particular arena has been Milord utilized by the promoter by giving a third party on rent 4,000 per month. He has utilized. So Milord, question of payment, my client is not agreeable. He has Milord fought for Milord,
very well.
and the
Only-
hearing was made complete. So Milord, your lordship.
Only, my lord, I will allow me to cite one judgment only. Then my lord decides the matter.
On what point?
This is reported in 2009 6 SCC 121. 121.
Yes.
Lord, kindly first take Lord paragraph 8.
Paragraph 8.
8. Not the second sentence.
What point, Mr. Chakraborty?
Not on the point of limitation. What was the duty of the commission? What is to be done? What the Supreme Court says.
Yes.
Paragraph 8, second paragraph, pertinently despite the specific plea having been raised by the bank.
Paragraph 8.
Paragraph 8.
Second sentence.
Second sentence. Pertinently, despite the specific plea having been raised by the bank that the complaint was time-barred, point of determination in this regard was neither framed not considered, like the present case by the district forum. Then para 10, as stated earlier, the State Commission affirmed the order of the District Forum and the National Commission also did not interfere with the concurrent order of the Consumer Forum. But similarly like us, then kindly take para 11, section 24A is quoted, kindly see after the quotation. It would be seen from the aforesaid provision that it is peremptory in nature and requires Consumer Forum to see before it admits the complaint that it has been filed within 2 years from the date of accrual of the cause of action. The Consumer Forum, however, for the reasons to be recorded in writing, may condone the delay in filing the complaint if sufficient cause is shown. The expression shall not admit a complaint occurring in section 24A is short of legislative command to the Consumer Forum to examine on its own whether the complaint has been filed within the limitation period prescribed thereunder. As a matter of law, the Consumer Forum must deal with the complaint on merit only if the complaint has been filed within 2 years from the date of accrual of cause of action, and if beyond the said period sufficient cause has been shown and the delay condoned for the reasons recorded in writing. In other words, it is the duty of the Consumer Forum to take notice of the 24A and give effect to it. If the complaint is barred by time, if the Consumer Forum decides the complaints are made, the forum would be committing an illegality and therefore the aggrieved party would be entitled to have such order set aside. Then 13, Supreme Court judgment British India is quoted. This court held that the question of limitation was a mandate to the forum, and irrespective of the fact whether it was raised or not, the forum must consider and apply it. Not kindly skip over, kindly come to paragraph 15. Section 3 of the limitation has been quoted, Lord. With reference to this was a case of Lord Ganmani Anaswa, where the Supreme Court quoted section 3 of the limitation and says it is for the court to determine the question as to whether the suit is barred by limitation or not, irrespective of the fact that as it is, whether such a plea has been raised by the parties, such a jurisdictional fact need not even be present. 16 is very important. Insofar as the present case is concerned, at the first available opportunity in the written statement itself, the bank raised the plea that the complaint was time barred by limitation. However, the objection with regard to limitation went unnoticed by all the three forums, namely district forum, state forum, national forum. Since the question relating to limitation goes to the root of the matter and may render the order illegal, we would now see whether the complaint was filed within the time within 2 years. Lord, kindly now come to paragraph 18. Lord, I have shown you lordships. Lord, kindly pause here for a moment. I have shown you lordships. 2005, I have refused. 2011, the last cause of action. 2012, the agreement was entered into. Then he has shown 2 dates of 2016. Kindly recollect, I'll take your lordships there. Kindly see what the Supreme Court says on the issues of showing dates by the complainant that this is the cause of action, para 18. The learned counsel for the complainant would, however, submit that the complainant sent various letters to the bank, like him. He said he has sent the agreement to me in July to the bank, and by their reply dated 11th March 1997, the bank asked the complainant to forward a copy of the letter dated 14th May 96 for necessary action. It was thus contended by the learned counsel for the complainant that the complaint filed on 5th May 97 was within time. We are afraid the letters dated 15th March 95, 4th May 96, 1st March 97 sent by the complainant to the bank and the bank's reply dated 11th March 97 are of no help to the complainant. The bank has not, by its reply dated 11th March 1997, acknowledged its liability. The bank only wanted the complainant to send a copy of the letter dated so and so for necessary. By no stretch of imagination can it be said that the limitation came to be extended by the bank's reply dated 11th March. As a matter of fact, the bank had communicated to the complainant long back, like us in 2005, by its letter dated 28th March 95, that the bills have been returned to BM Konar, sales manager for the complainant, and on 10th March May 94, the matter should be taken up with him. The complainant filed 5th May 97 is even beyond the 2 years therefrom. There is no application for condonation of delay, not sufficient cause shown. Therefore, the question of condonation of delay in filing the complaint doesn't arise. But at the risk of being admonished by your lordships, kindly take the complaint once, one paragraph only. It starts at page 146. Just take one paragraph only.
Please sit.
Lord, first take paragraph 9, 140, 151. It says abruptly to the greater misfortune, complainant opposite party on 14 June 2005 to the reason best known to her by a letter intimated the complaint she was unable to register the car parking. First point of refusal, very clear to him. No doubt about it that we said that we cannot register the car parking. Then it continued. Lord, kindly take one more paragraph. He says that in 2011, up to 2011, we discussed. Let us take his case to the best possible extent. Kindly come to page 155. In 154, he says up to 2011, 155, he says that, but to the utter surprise of the complainant, opposite party again on 16 December 2011, likewise previous occasion, denied to register at the conveyance directly. So I denied again in 2011. Then he says that once again, to avoid further delay, the complainants were compelled to register the said agreement 19th April 2012. Let us take that both of us went for the registration. Lord, page 155. My Lord has got that. 19th April 2012. Then he explains the limitation by saying, kindly come to page 156. As such being frustrated, my Lord has got that. As such being frustrated and fed up without seeing the light of the end of the tunnel, complainants personally handed over the opposite party the affirmed deed. Like the other matter, which I have shown, relied on, he says that he came and handed over. On June 2016, it must be mentioned that such draft of the deed also given to the earlier 2012-2016. Then in the next paragraph, he says he waited for 12 years. So the only thing that he has said in 2016, that on 21st June, he came to me and handed over a copy. And he says by that, the limitation has been extended by me till 2016. He filed it in 2016. The first refusal 2005, second 2011, then agreement entered into April 2012. And he says he came to me, handed over a copy. My lord may come back to the judgment I have cited. It says that by giving letters,
Cannot be extended.
and it goes to the root of the matter. Now, that was my first submission.
Application of the code under section 3 of the Limitation Act.
And here, my lord, the statute says it's the first duty of the forum to look into whether it is barred by limitation or not. I made a point, specific point in the written statement that was, my lord, not considered, like the case I have handed over. Supreme Court, my lord, considered that and says it cannot be entertained. Now, my lord, second point which I have taken, I don't want to, my lord, re-argue. I have taken 2 points in my limitation application before the state forum, which was not considered. And, my lord, the appeal before the National Commission under the old act, there was no provision for second appeal. That, my lord, was wrongly filed, I believe, my lord. So it is not a, my lord, concurrent finding. Under the old act, 1986 Act, there was no provision for, my lord, second appeal. Under the new Act 51(2) says, although there will be no appeal, my lord may have a look at the statutes once. Subject to your lordship's kind correction, my lord may have a look at the old act first and the new act.
Yes. Here the complaint was originally before the district commission.
Forum, then state, then national, take the old act first, then the new act. I have given your lordship both.
Yes.
Take the old act first, not the corresponding sections.
Old act, I think there is no second appeal before the commission. It's only a revision before the commission.
Even revision, I believe it could be only against the original jurisdiction exercised by state forum. That is under 21.
Where is the
Lord, kindly take section 15, 17 and 19. Lord, 15, and any person aggrieved by an order made by the district forum may prefer.
Person aggrieved by an order made by the commission in exercise of powers.
My lord is reading 15.
May prefer an appeal against such order to the within a period of 30 days. So it's 17.
17A1. That's the original jurisdiction. Kindly see 17. 17A1 is the complaints were filed before the state forum.
So original complaint.
Original complaint.
So there is no second appeal against.
Yes. Now kindly take 21. Take 21. The jurisdiction of the National Forum. The jurisdiction of the National Forum is twofold.
One is original, another is revisional.
Revisional. Now that revisional kindly sees to call for records and pass appropriate order in the matter of consumer dispute, not an appeal. So the National Commission under 21B cannot exercise revision or subject to correction by your lordships against an appellate order, against an order passed exercising appellate jurisdiction by the state forum.
Against which order revision will lie?
Not against the. Lord, kindly appreciate this. It should be read. Kindly take note. Kindly says to call for records and pass appropriate orders in any consumer dispute which is pending before or has been decided by the state commission, where it appears to the National Commission that such commission has exercised jurisdiction not vested in it by law. Appellate jurisdiction, if there is no exercise of jurisdiction which is not vested, in my humble submission, there can be a revision. But in the present case, we have preferred an appeal not directly before the state forum, the impugned order, National Forum by the impugned order. Under 51A2, under the new act, there is a provision of appeal. My lord may have a look at 51(2). Perhaps to eradicate this confusion, the legislature will introduce 51(2). In any event, it goes to the root of the matter, the limitation question. It has to be decided. It has not been decided.
So according to you, this power of revision is available when?
Lord, because the jurisdiction of state forum, kindly take the jurisdiction of state commission once.
Yes. No, I'm asking you when.
Yes, the jurisdiction of the state commission is limited to 20 lakhs. One in the original jurisdiction.
Yes.
Now, if the state commission entertains any proceeding which is beyond this jurisdiction, then Milord, perhaps 21B could be invited in my humble submission.
Only on that.
Because it refers to dispute, not appeals. The language. No, otherwise, there was no necessity to bring in 51(2).
Mr. Chakraborty, so according to you, if let us suppose a consumer dispute within valuation.
Appeal.
State Commission's valuation is what is the pecuniary?
Under the old act, it was 20 lakhs.
So let us take 20 lakhs. So 15 lakhs is being decided by the State Commission.
No, 20 lakhs, but does not exceed 1 crore. 20 lakhs to 1 crore.
30 lakhs. So if it is a 30 lakhs consumer dispute decided in one way, whether revision lies under 21 directly to the National Commission if a person chooses not to go for appeal.
Lord, under say 19, he can prefer an appeal against the
He
original.
does not choose, because 21 revision is also there. One may choose, all right, I will not go to appeal, I can go to revision.
Lord, revisional jurisdiction
Because
perhaps
according to you, it's the original jurisdiction against that revision.
because it says
So,
consumer
and it has
dispute.
been decided.
It says
Or has
consumer
been
dispute.
decided. Pending or decided.
Decided.
So let us take it has decided.
For
finally
against
decided.
pending, he can go. Against
Let us-
pending, he can go.
Or
Yes, or
let us exclude pending.
or
So decided.
yes.
So an original proceeding decided by the State Commission.
Yes.
So revision before the National Commission,
Yes.
not appeal.
No.
He can go. He has two remedies: appeal and revision.
Lord kindly appreciates this. If my lord,
Everything says though that.
if my lord reads it with 51(2) once, kindly read it with 51(2) once. Just have a look at it, because the legislature has consciously introduced that provision. Kindly have a look at it.
Yes, 51.
2. This was not there in the earlier act. Subject to correction by my lord. Save as otherwise expressly provided under this act by any law, because 19(1) also talks about original jurisdiction and appeal. Time being forced, an appeal shall lie to the National Commission from an order passed in appeal by the State Commission if the National Commission is satisfied the case involves a substantial question of law. So this provision of second appeal on a substantial question of law, 51(2) has been introduced under the new act. In the section 19, this provision was not there.
I follow that.
Yes.
There is no dispute.
Perhaps since the 21B uses the term dispute, not an order or appeal, perhaps that subject to
That is what I am asking you. So
perhaps
if
it will be
if
only
a
against
State
the
Commission exercising original jurisdiction,
my lord may have a look at this judgment, my lord. Paragraph
Yes.
6.4. This is reported in 2019 6 SCC 424. I am reading it for your lordship. I am handing it over.
this is under the 86 Act.
Yes, this is under the 86 Act.
Yes. Yes, yes, read out.
Consumer dispute to
This was the consumer dispute has been defined. The National Commission has under 6.3 it says original jurisdiction to entertain complaints where the value of the goods services exceeds ₹1 crore, jurisdiction to entertain appeal against the order of State Commission, supervisory jurisdiction over the State Commission in any consumer dispute pending or decided which is challenged on the ground of lack of jurisdiction, and to exercise divisional jurisdiction 21B, National Commission is limited to a consumer dispute which has been filed before the State Commission. The jurisdiction under 21B can be exercised by the National Commission only in case of a consumer dispute filed before the State Commission. National Commission exercise supervisory jurisdiction under 21B is concerned about the correctness and otherwise of the orders passed by the State Commission in a consumer dispute. Now, I was trying to download this because of the internet. I could not download, but I got it from the textbook reference. But this 6.4 says, but ultimately what is the conclusion, Lord? I'll just get a copy and give it to your lordship. It had a print Koreano judge immediately. But Lord, here in this case, what is being done? A second appeal was preferred.
I appreciate that. According to you,
So under 86 Act, no second appeal could have been filed under the 86 Act. Number one. Number two, the jurisdictional issue or the limitation issue, which goes to the root of the matter, has never been touched by any forum, which Supreme Court is, it was the duty of the court to look into. And my limitation.
Can you blow hot and cold at the same time, Mr. Chakraborty? You went before the National Commission in a second appeal.
Lord,
now you are saying
that was, since your lordship was not on the last occasion, it fell from a concurrent finding. I said that
I'm asking you,
the appeal ought not to have been filed. I say it was ought
I'm
not to have
asking
been
you
filed.
when you have approached.
I have filed. I
Can
cannot
you
deny
say
the fact.
Can you say no?
I say it ought not to have been filed, but it has been filed. But not my main point of argument before your lordship is that not the jurisdictional issue.
Have you stated that it ought not to have been filed on affidavits here?
No, that has not been said.
Will you take the responsibility of saying that? This Mr.
my-
Chakraborty, you have to make that stand clear on
Not my-
affidavits that appeal was not maintainable, that was wrongly filed. You have to make that statement on oath.
I will come back with that affidavit from
Yes,
the
because
client.
that's necessary. If you want to make that submission that was made by mistake, you have to state that by way of oath. That you have to
It
state.
is a
Now,
question of
thereafter, you will say, no, that was not my
it is a
submission.
question of law coupled with the fact that the appeal was filed. But in my humble understanding, under the old act, under the new act, there is a second appeal provision. Under the old act,
Mr.
there's no
Chakraborty,
provision.
that's your submission.
And the
But
appeal
you are
was filed,
saying, I asked why you filed a second appeal. You have said that was by mistake.
and the second appeal was
That's a
filed.
fact. That's a factual thing.
Yes,
you have to
absolutely.
state by way of an affidavit.
And the
that
second
was done by way of a mistake.
and the second appeal was filed under the provisions of the new act. It could not have been filed.
That is why.
So, my lord, my humble submission before lordship is, my lord, a litigant whose main question of jurisdiction has not been dealt with by any forum. He approached rightly, wrongly, national forum. Today he is before your lordships, and my lord, the state forum has not dealt with the issues raised by us in the Section 5 application. The main issue, it could have been rejected. It has not been touched. That I was unwell, my husband was looking after the matter, I shifted to my daughter's place. Not even touched. Not even touched. Number one. Number two, the jurisdictional point, my lord will kindly consider what Mr. Mukherjee's case is, that he came and handed over the registered copy. That's the only incident happened post 2012. That cannot, my lord, extend the period of limitation. If it is barred, it will be barred. It cannot be entertained even. Kindly considers, my lord, the MSME Accounts Act. MSME Section 19 appeal. You have to make a pre-deposit, court cannot entertain. There's a difference between filing and entertain. He can file, but it will not be entertained. So the district forum should not have entertained the petition. That's my submission. And since you
should not have admitted the complaint.
Admission will come after entertaining the petition, like Electricity Act appeal, like DR Surface Act appeal. You have to make a pre-deposit, court cannot entertain. But I am not saying that he cannot file. He can always file a petition. But it is the duty of the court to look into it, whether the court will entertain or not. Even if I have not taken the point. That's the Supreme Court says. But I have taken the point, not considered, not decided. Do not shut me out of this proceeding.
Mr. Chakraborty, do I accept your submission that appeal before the National Commission was non-est in the eye of law, since the proceedings emanated under the 1986 Act, so the appeal was not maintainable. So you are in effect assailing the order of the State Commission.
That's my submission. That's my submission.
That's your submission.
Submission on a question of law. Now, the
And
litigant.
the question of so revision power is there. So without availing that revision, whether 227 can be entertained, that issue will also come then.
The petition was for revision.
That issue will also come then.
The petition was filed under 58(1)(b). The petition which is filed before the National Commission.
Chakraborty, yes, I appreciate cannot be under the new act. So you are assailing. So according to you,
Even if it was
under the 86 Act.
And let us say that even if it was a revisional petition. Let us say that even if it is a revisional petition.
I'm not saying
It
that.
was.
It was filed under 58(1)(b). Let us say that it was.
Or I could not make myself clear.
I understand. Then
What did you understand?
Lord, that I have not exercised my remedy under the revisional jurisdiction before the National Forum.
Under the 86 Act.
Under the 86 Act 21(b), which your lordship says, but if the Supreme Court party judgment. Under this judgment, I believe 1906 judgment, the State Commission, National Commission could exercise only jurisdiction or revisional jurisdiction against the proceeding initiated before the State Commission. My lord will see that. But my lord, the main, irrespective of whether it was a revision.
Those judgments under the 86 Act, where the Honorable Supreme Court deprecated the practice of entertaining 227 in consumer forum matters, also bring those judgments. There it has been said, then revision, don't entertain 227. Those
Well-
line of decisions where the Honorable Supreme Court deprecated, High Court should not entertain 227.
Unless the remedies are exhausted. Lord,
So those
Lord-
line of decisions you have to bring, those were under
Lord-
the 86 Act.
Lord,
Those are staring at your face.
Lord,
Once you say
Lord,
my appeal was not maintained,
Lord
that is why
Ibra,
I wanted you to make those
Lord
statements
Ibrat,
on oath.
Lord Ibrat Faizan was the first judgment, perhaps subject to correction, where the Supreme Court says that you have to exhaust your remedy.
So, Mr.
Then
Chakraborty,
you
if
come.
you want to take that step,
Lord, what I am,
please make a
Lord,
statement on oath.
my submission
Then,
before your lordship is, that, my lord, I can say, my lord, I will couch it as an alternate submission. First submission states, my lord, that it was the jurisdiction point limitation has not been considered, and my case for condonation of delay has not been considered by the state forum at all.
That's one way.
That is one way. The second way, with regard to the appeal filed before the National Commission, my lord, I, as an alternative submission, I say this, my lord, that the revision, whatever was filed, that was filed under the new act, which could not have been filed. The petition, if my lord sees the National Commission petition, it was filed under 58(1)(b), like 21(b), exercising the revisional
Give
jurisdiction.
me that revision file.
Yes,
number.
just give me
Page.
judgment on. Just give me a second, my lord. Appeal before the NCDRC. Starts at 73.
Only 73.
Yes. Kindly come to 98. কি করা যাবে এখানে আটকে গেছে বাইরে করাতে পারবো না টাকা দিয়ে ডিসপিউট মেটাবি না my lord, it may have been wrongly quoted 58(1)(b), it could have been 21(b) also. So, Lord, if for the present, if my lord considers that, but this is my understanding of law, that it could not have been entertained subject to correction by your lordships.
Why?
Because from the state forum, it could only be from the original jurisdiction. That is my understanding of law. Judgment ante পাঠিয়েছো? তারপর So, my lord, that is why I made this submission.
After looking at 58(1)(b), you are saying that.
Lord,
Mr.
only
Chakraborty.
look at 58(1)(b) once.
Similar language as in.
Similar language 21(b), similar language, absolutely similar language.
All right, I will deal with that submission of yours. No
Similar
problem.
language. Only point is that, Lord, I say that perhaps in my humble understanding, that it could only exercise jurisdiction since the word used
No,
dispute.
that since
My lord-
what used is consumer dispute.
Dispute. The dispute means a dispute filed originally before the next lower forum, subject to correction by my lord. And 2019-6, I'm getting a copy. I'll give it to your lordship.
So now 58(1)(b) uses the same language.
Of 21(b).
Yes, consumer dispute. So how do you read this? Against which order this revision will lie?
Now, my lord, with regard to the 86 Act,
No, 2019 Act. Now let us
2019
come
Act,
to 2019 Act.
Lord, kindly take me, Lord, 58(1)(b).
Yes. So this is against the original.
Call for records appropriate order in the consumer dispute.
So original.
Since the word is used consumer dispute, it has to be any order passed by the state commission exercising original jurisdiction where the state commission lacked jurisdiction or failed to exercise jurisdiction.
Can it not be taken in appeal, Mr. Chakraborty?
Yes, it could be taken in
So
appeal.
if Mr.
taken in appeal also.
Chakraborty,
But
the
against the
scope
pending
of-
matters,
Mr. Chakraborty,
it could go.
Chakraborty, please take this. Scope of appeal is wider.
Yes, yes, absolutely.
So if an order can be assailed in appeal, all points are available. Why one will go before the revision?
Have a look at
Don't
this.
you think that
Have
this
a look at this
provision,
one.
yes, which
Have a look
paragraph?
at this once.
Which paragraph?
I may be wrong, my lord. This is your lordship will decide.
Yes.
Kindly take me, lord, from paragraph 6. The issue which arises,
Paragraph 6.
the issue which arises for our consideration in the present appeal, whether a revision petition is maintainable before the National Commission under 21(b) of the 86 Act against an order passed by the State Commission in an appeal arising out of the execution proceeding. Execution proceeding. It was an order arising out of execution proceeding. Then the right to file a revision petition like an appeal is a right conferred by a statute. In the absence of statutory conferment, there is no inherent right to file a revision. Section 21B is set out. 6.3, the National Commission has, Supreme Court says, original jurisdiction. Then takes 6.4, the exercise of revisional jurisdiction on 21B of the National Commission is limited to a consumer dispute which has been filed before the State Commission. The jurisdiction under 21B of 86 can be exercised by the National Commission only in case of consumer dispute filed by the State Commission. The National Commission in exercise of the supervisory jurisdiction on 21B is concerned about the correctness or otherwise of the State Commission in a consumer dispute within court. The revision petition has a narrower scope than appeal, that not quoted. Then 6.6, judgment quoted. Ordinarily, power of revision 6.7 can be exercised only when the illegality, irrationality, impropriety is found in the decision-making process. Revisional jurisdiction confirmed by the National Commission under 21B is with respect to a pending dispute or disposed of consumer dispute before the state forum. Consumer dispute before the state forum, para 7. 7.1, consumer dispute in the present case has already been finally adjudicated by this court by judgment dated. The second round of litigation, my lord may skip this. Section 25 quoted. Yes. Para 7, it says consumer dispute. Then paragraph 7.8, there is no remedy provided under section 21 to file a revision petition against
paragraph
7.8.
You will skip paragraph 7.3, Mr.
No,
Chakraborty.
I did not skip. I'll read it.
Please read paragraph 7.3.
Yes, the nature of execution. No, that was out of an execution proceeding.
Please read the
Is
paragraph.
materially different from the nature of the proceedings for adjudication.
To that execution revision is not maintainable.
Paragraph 7, paragraph 6.4, and ultimately, my lord, paragraph 8, if my lord says, it was paragraph 7.8, 7.9.
Yes.
7.8, 7.9, there is no remedy provided under section 21 to file revision petition against an order passed in appeal by the State Commission in execution proceeding. Section 21B does not provide for filing a revision before the National Commission against an order passed by the State Commission in execution proceeding. The present case, National Commission committed a jurisdictional error by entertaining the revision petition 21B by the appellate board against the appeal preferred by the State Commission in the execution proceeding. National Commission erroneously allowed the revision petition to be maintainable. Furthermore, National Commission modified the decree passed by so and so. My lord, kindly come back once to 6.3, 6.3.3 and 6.4 once.
6.3
and 6.4 once. 6.3.3, supervisory jurisdiction over any state commission in any consumer dispute pending or decided by a state commission which is challenged on the ground of lack or excess of jurisdiction. The exercise of revisional jurisdiction under 21B by the National Commission is limited to a consumer dispute which has been filed before the State Commission. The jurisdiction of 21B Act can be exercised by the National Commission in a consumer dispute filed before the State Commission. National Commission in exercise of supervisory power 21B is concerned about the correctness or otherwise of the orders passed by State Commission in a consumer dispute. And 7.3 says consumer dispute and execution proceedings are different, but my lord, it was not a consumer dispute filed before the State Commission. That's my submission, my lord. Apart from that, the jurisdictional issue has not been decided by any forum. Lord, these are my submissions, Lord. And I'm grateful, Lord, my Lord has given me an opportunity. Lord, correct me if I'm wrong, Lord, that your Lordship will decide ultimately.
If you want to file any written notes, Mr. Chakraborty, you can file that.
But I have tried to resolve the dispute between the parties, Lord. It may not.
Mr. Chakraborty, I wanted you to take instructions.
I have
between
taken,
the parties.
he has also
Mr.
taken.
Chakraborty, it's between the parties.
No,
After all, the parties, whether to agree or not.
But not only for a 250 days delay, my defense will never be considered by any court. That's also too harsh. When they said that they have come after 12 years. Yes, in the complaint itself, I have waited for 12 years, para 16. These are my submissions, Lord. I'm grateful to Lord.
Mr. Chakraborty, Milord, very conveniently by showing 2009 judgment, Milord has tried to take
2019 judgment.
No, Milord, first Milord, 2009 volume 5 SCC, page 121.
Yes.
Milord, Mr. Chakraborty tried to Milord persuade this court Milord to go into the aspect with regard to Milord the scope of the revisional application as to whether
Lord,
my complaint
Lord,
is
may I-
filed within the time of limitation or not.
One matter is called on, Lord.
But he has to choose, Milord. Kindly takes up that judgment. What happened in that judgment? It is also a case, Milord, arising out of 1986 Act. The case in hand, which Mr. Chakraborty relied, there also initial dispute was filed before the district forum. Appeal, Milord, if your lordship consider, Milord, only paragraph 2, 3, and 4, my lord would found that it was a dispute initially filed before the district forum, thereafter went to the Milord State Commission, and thereafter National Commission, and thereafter the Supreme Court is considering this. So, if Mr. Chakraborty wants to take aid of 2019 judgment, he should not rely upon the ratio of this judgment then. It's exactly the opposite. And Milord, this judgment is Milord emanates from a dispute which has not ended. Why I say? Because Milord, ultimately the appeal went before the Honorable Supreme Court. Supreme Court is on the session of the matter and is of the view that yes, the initial complaint may have been filed ex facie bar, and the forum ought to have gone into the matter. Today, the matter went up before your lordship after Milord the forum, the State Commission and the National Commission found that
Yes, because paragraph 10 is clear.
yes, paragraph 10 is also clear.
State Commission affirmed the order of the District Commission, and the National Commission also did not interfere with the concurrent orders.
So he has to choose. Now, the secondly, Milord, with regard to my ex facie, Milord, bar, Milord, I have argued. I will not again reopen because it's the Milord 2005, 7, all the old chapter. Once Milord, both the parties agreed and Milord presented the same for registration, Milord, the previous Milord acts and deeds Milord goes away. And thereafter I have explained and I have come within period. So ex facie, Milord, Mr. Chakraborty argument will not do. And section 5 I have.
So you have approached when? 2018?
2016.
2016.
2016, I after Milord the registration is being done, I waited again.
That's
the registration.
2012.
That's 2012. Thereafter,
So, 2 years is 2014, Mr.
No, Milord, it's then also Milord from the refusal. I pleaded, Milord, in my Milord application, I pleaded specifically in 2016 again. After this registration of the agreement for sale, again a draft is being presented to him. When he refused at that juncture, thereafter I come. And I have shown before your lordship, original agreement does not contain any time limit. So I am in the second part of Article 54. So in any event, Lord, it cannot be said at ex facie bar that Mr. Chakraborty. And Lord, section 5, I have argued one paragraph itself suffices that no court should exercise its Lord discretionary jurisdiction. Once blatant lie is being said that no, I completely was not aware of the proceeding or anything. It's my husband who has looked after the matter all along. And thereafter, the address change also I have shown before your lordship. And exactly on that score, the National Commission also, Milord, paragraph. Why, Milord, I say, Milord, discretionary jurisdiction under Article 227 cannot be exercised, may not be, I cannot say cannot. Milord, paragraph 7 of the National Commission's judgment. National Commission, Milord, also, Milord, is of the view that it's a subjective satisfaction of a forum. It's not about you or me. It's something, Milord, it can be, Milord, subjective satisfaction before a single forum, cannot be, Milord, in another forum. But revisional jurisdiction, Milord, your lordship knows, Milord, if a second opinion can be formed, that cannot be a ground for interference. That's, Milord, mine.
Yes. Written notes, when can you file?
A week, my lord.
Heard, Mr. Chok. uh, let the matter stand.
Well, I got the petition, my lord. It's listed for release, my lord. It's for Baripur Court, my lord.
Since I'm not inclined.
Lordship, this is listed for correction.
Lordship, I'm from the
IMC
opposite party.
Limited has been shown as ITC Limited. The cross title, Lordship, IMC Limited, it has come down as
Title
ITC.
has been wrongly.
Yes, Lordship, that's.
Lordship, if a copy of the application could be served upon us.
It
And
has
for
been-
the Port Trust,
What application?
the civil application, Lordship, we have not been served with a copy.
Lordship, we intimated them immediately upon receiving the order.
You have served.
Yes, Lordship, not the order.
Not received instructions. The copy has been served to the Port Trust, probably.
No, you have only served the copy of the order.
I have not served the copy of the order, Lordship. I was waiting for it to be corrected. I have intimated them about the order and I will be serving
You have
upon.
an extra copy of the application.
I am taking her details, Lordship. I'll serve it today itself.
The learned
My lord, I'm also for the petitioner. This is an application for extension of interim order, my lord. My lord, your lordship had granted this order first on 17th July 2025. And my lord, subsequently it was extended on 8th April
Have you
2026.
served upon the other side?
Yes, my lord.
Where is the
Affidavit
evidence
of-
service?
Yes.
Evidence service filed in court today is taken on record.
Since then, we have served all the applications, but the opposite party has not appeared as yet. They have not even filed wakalatnama. I'm kindly praying, my lord, to extend the application of the order till the disposal of this application.
Yes, next.
And my lord, another indulgence, man, there needs to be a correction in the cause title.
Of which order?
Of opposite party number 1, the name is SK Plantation Private Limited.
দেখে নিন যদি first টাইটেলটা correct করে।
My lord, I am for the petitioner, my lord. This is for extension of interim order. Interim order of the dated 21st August 2025. My lord, on the last occasion they have appeared. The opposite party has put into appearance in the CO.
When they appeared?
And
have you served a copy of this application?
Yes, my lord. Yes.
For whom? Where is the evidence service?
I have just now I filed.
Taken in service are checking.
On 8th of April, they have appeared.
Can 3 of 2026?
Can
When?
3 of 2026.
You are appearing.
I'm on behalf of Janta Das, I am appearing for this.
After hearing the learned advocates for the
In this matter, I am appearing for the petitioners, my lord. My lord, the petitioners being the being the defendants, my lord, they are implicated in the suit, my lord. My lord, actual facts remains that my lord, RS Dag numbers 2735 was a
What is the
long
impugned order? What is the impugned order?
yes, my lord.
What is the nature of the impugned order?
Impugned order, my lord, order 7, rule 11, rejected, my lord.
Rejected. Order 7, rule 11 on what ground?
On ground that the petitioner, my lord, are not the, my lord, related with the land. Because,
That's
my
a
lord,
dispute which has to be
they are demanding rights, my lord, on the basis of the RS record of rights.
That has to be decided in the suit.
But
how
my lord,
can it be order 7
not
rule 11?
related, my lord, not related at all, my
That
lord.
cannot be decided in order 7 rule 11.
My lord, not related, my lord, because, my lord, that is, my lord, long ago, my lord, they left India. The original.
He will succeed in the suit will be dismissed. Ashun, this application under Article 2.
Thing, I have
For
come.
the next matter.
8, item number 8, my lord.
Yes.
My lord, on earlier, my lord, kindly have a look into my lord, page
Yes,
number.
expeditious hearing of what?
My lord, is the eviction shoot, my lord. Other shoot. It is written as other shoot. It is pending before the Land Civil Judge Junior Division, Second Court.
What is the stage of the suit?
My lord, it is the stage, my lord. Evidence is going. Evidence is going on.
Evidence is going.
Yes, my lord.
What was the date fixed for evidence?
My lord, that is, my lord, 5th day of August.
5th day of August. Injunction application disposed of. When it was disposed of?
My lord, in the month of June, my lord.
This application. Page number.
Within a period of 6 months. That was ordered, my lord, by this honorable court on 5th day of December 2025.
That was at the stage when the injunction application was also pending.
It is the shoot, dispose of the shoot.
Cannot be done within 6 months, sir.
That is written in the order sheet. That is I am saying.
You have not drawn the attention of the court that the injunction application is pending. At that stage, you have prayed for expeditious disposal of the suit. What can be done?
My
This
client is
application,
80 years, my lord. 80 years.
sir, that cannot expedite. You have to consider the stage.
That's like
Unless the
that's
interlocutory applications are disposed of,
I
the
am
suit
praying
is.
for my lord, sympathetic attitude may kindly be, my lord, taken.
In this way, you are taking expeditious hearing directions. You will not get any benefit of that. Because they have to proceed in accordance with law. Trial court cannot
make some observation so that, my lord, mechanical way.
Application under Article 227 of the Constitution.
It is also the, my lord, similar
Again,
matter.
expeditious hearing.
Yes, my lord.
Same
Similar,
court.
same court, my lord.
Yes.
As deep,
Only your matters will be taken up by the court. No other matters will be taken up.
Here also, my lord, similar order was passed by the.
Dispose of the suit within 6 months.
Yes, my lord. 12, page number 12.
So, after expiry of 6 months, you have again approached.
6 months have already been done. 5th of December 2025. And it is.
When did you file the application for injunction? This application under Article 227 of
I am for the petitioner. I am for the defendant petitioner.
Yes.
Suit is for declaration of right title interest and
order under challenge.
expediency has disposal.
Rejected. Rejected.
My lord, suit was filed, my lord, for
If it is
declaration of
moved
right.
by the senior, it will be rejected, Mr. Mahato.
Oh, then I.
Your Lordship, this is arising out of a suit for right declaration of right title interest.
Yes.
Your Lordship, on December 10, 2024, the issues were framed, and Your Lordship, injunction application was filed by the plaintiff. It was dismissed, Your Lordship.
So injunction disposed of.
His injunction has been disposed of.
Now, what is the stage?
Stage was, Your Lordship, it was fixed for preemptory hearing. The plaintiff filed one application for withdrawal of the suit from the preemptory hearing. That was also been allowed, subject to cost. And Your Lordship,
has been paid.
It has been fixed on July 20, 2026 for payment of cost, and another application they have filed for application for interrogatory. That is only pending. And in the meanwhile,
When it is pending.
yes, and in the meanwhile, they have been
When
taking.
it is pending.
It is at pending its Daton court.
No, when? What is the date?
Date, Your Lordship, on March 25th, they have filed their application. It is fixed on 20th of July, 2026.
20th of July, 2026.
Next date is fixed.
Application for interrogatories.
Yes, only that application is pending, Your Lordship.
That's 25th of March, 2026.
It was filed
on 25th of
March 26.
This application under Article 220.
11, my lord, I appear on behalf of the petitioner, my lord.
But I have instruction to appear on behalf of the plaintiff opposite party number 1.
Plaintiff opposite party number 1.
Yes. I'm the defendant petitioner, my lord, suit for eviction of trespasser, my lord. My show cause application for acceptance of
Suit for eviction of a trespasser. 2G. 2G. When you will vacate?
My lord, I will vacate. Let
When,
them
when?
obtain a degree, my lord, I will vacate. Let them obtain a
He
degree.
will have to vacate.
Let them obtain a degree, proceed with the execution. I
They
will
will not get a degree.
No, my lord, they will.
They will get a degree.
Lord, let at least a chance be given to contest the suit, my lord.
Why? What happened?
My show cause application for late acceptance of written statement has been rejected. Lord, 3 orders have been.
So, 3 orders are under challenge.
Yes, my lord. Kindly, my lord, takes up the first order, my lord, 26th of March 2019.
2019 order you are challenging now.
Oh, my lord, thereafter, my lord, I have filed an application for reconsideration of that order. That application has been kept pending and the next date has been fixed for 9th of July 2026 for show cause by the defendant number 1 and further examination of PW1. But if the suit proceeds and examination of PW1 continue, what will be the fate of my application for reconsideration of that earlier order? That has been kept pending, my lord. That has not been rejected or allowed.
Where is your application?
My application is at page 26. My lord, reconsideration application is at page 33.
Page 33.
Page 33.
Which has been kept pending.
Yes, this has been kept pending. I have filed the written statement that was taken on record. Kindly, my lord, seize this order, my lord, 28th of November 2018.
Written statement filed within time.
No, beyond time. On 28th of November 2018, my lord, I have filed. Court has taken on record.
When the summons was served upon you?
31st of May 2018.
31st of May 2018.
May 2018.
Then what happened?
But thereafter, I have filed on November 28th of November 2018. I have filed a written statement along with an application for show cause. Now, my lord, my show
What is
cause
the ground of show cause?
Lord, medical. Lord, that
Medical
application.
document prescription you have annexed.
Yes, supplementary I have given page 29, my lord.
Page 29.
Page 29.
What was the illness? What was the nature of illness?
Fever with chill. Lord, page 31. The prescription is there. Vomiting often, giddiness, and anoxia.
Lariago, malaria, without test. Mr. Mondol.
2018.
How can it be? Without test. It's a medicine for malaria. Dosage has been mentioned.
Yes, my lord.
First day, how many dose? Second day, how many dose? Third day, how many dose? That too without any medical test. Are you rely upon the medical document, Mr. Mondol?
This was given, Milord, in the supplementary affidavit, Milord.
Then I have to call the doctor then. How could this medicines be prescribed without any finding that there is a suffering from malaria?
No, Milord, test has been given. Advice in the blood.
Prior to that, these medicines will be administered. I have seen, Mr. Mundol, blood for TCDC.
Yes.
That was prescribed on a date on which date the medicines were also prescribed without looking at the test reports. The doctor knew that what will be the test report beforehand. Yes. Then
Lord, let my application for reconsideration of that order be first taken up, Milord.
2019, 26th of March 2019.
Yes, yes,
Where
yes.
is the first page of
First
that
page,
order?
Milord, yes. That is in the bunch, Milord. That is in the bunch, Milord. I have folded.
That is in the bunch.
Yes, yes.
No, in the certified copy, why?
No, Milord, that my filing clerk has missed that.
Where is the original copy?
Original copy is with your lordship. The original certified copy is with your lordship.
No, their first page is not there.
Milord, I am taking from the.
This is an order passed on 26th of March 2019. The
Yes.
conduct is so alarming. This reconsideration application, Mr. Mondol is asking, Lord, that to be considered. This has been filed only on 19th of June 2026. And in the interagnum,
2026.
And in the interagnum, the suit got posted ex parte hearing against defendant number 2 and 3. He filed recalling application that has been rejected.
No, Milord, only one thing, Milord. On 26th of March 2019, court takes up my show cause application. My show cause application gets dismissed, gets rejected. And Milord, court, Milord, then suo motu proceeds that let the suit be fixed for ex parte hearing against defendant number 2 and 3. On that date, I was present. How can the court fix for ex parte hearing?
The show cause was not accepted.
Did you challenge this order, Mr.
Yes, this
when
order,
did you challenge?
in this revision only.
What is the explanation for the delay? 2019 order you will be challenging in 2026?
No, Milord, I have prayed for Milord reconsideration, Milord. That
That is
application
also
is
in 2026.
Reconsideration, Mr. Mukherjee is saying you have filed in 2026.
19th June 2026.
So,
after about not 8 years.
but only one thing, Mr. Mukherjee, if he appears, he cannot be deprived from the
No,
right
Milord,
to contest.
No, that's Milord, that's the order, Milord, I have handed over. He was, Milord, given a show cause. Milord, since his conduct, he is not appearing. So his show cause, Milord, is not accepted.
He is also not appearing.
No, initially, Milord, in the interagnum period did not appear. Show cause was issued. Show cause answered. The court found the show cause is not satisfactory. That is also turned down.
No, but maybe Mr.
2024. I do not know. Mr. Mondol is challenging that order also.
Yes, he has challenged many orders. All orders, I think, from 2019, all orders he has challenged.
2024.
All order, yes, it's 2024, 7th of November 2024. Yes, that order also he has challenged.
He filed 7.
Any other order left, Mr. Mondol? No other order left. Yes. Where is 7th of November 2024?
7th November, blood setting aside ex parte was rejected.
7th of November.
Yes.
Setting aside ex parte, Mr. Mukherjee, even if it is rejected, he has to be given an opportunity to participate from the stage when he appeared. That right he has. You cannot take away that right.
No, Milord, because of the series of order will say, because of his conduct, he is not coming up and disappeared himself, Milord, for years
taking,
together.
Mr. Mukherjee, even taking
Yes,
your
yes, that's
case
the
to
law.
that height
That's the law. Yes.
there is no reasonable cause, no good cause, no cause even.
No,
cause
yes,
even
he has
to,
a right, Milord, to contest, but his conduct is so alarming. That's from 2018.
then you cannot take up because if a person is present on the date,
but kindly consider, Milord, your 2019 order reconciliation application filed in June 2026, whether that can at all be not considered by the trial court.
But the trial court could have rejected. It's pending.
It's pending.
That's not from the order sheet. I also find that the application has not been dealt with.
If both of you want, I can decide it that reconsideration application here and now. If both of you give
I can
consent,
concede without being a landlord. Without
he is not consenting.
Let the trial court decide. Let the trial court decide.
Why?
I have already, my evidence has been tendered. It is in such a position. Kindly, direct, if your lordship is of the view that this application needs to be dealt with, then a time frame be given. From 2018 already,
what is the next date fixed?
Next date.
9th of July was given. Thereafter, I don't know.
Oh, 28th July for further evidence. That's from the PIS system. 28th July is the next date for further evidence.
But the hearing of that application has not been fixed.
No.
The consideration.
That we can concede that on that day we will hear out. If necessary, objection file করেছেন ওটা ওদের reconsideration I shall file objection, written objection in the meantime, and direct the learned trial judge, request the learned trial judge to hear out that interlocutory application on that day itself.
That now, Mr. Mondal, are you proceeding with the other applications? Challenge against the other applications?
So this stems out from 26th of March 2019 order, this reconciliation.
No, but if I direct that, what will be the fate of, because you have challenged those orders before this court also.
Yes, my lord. But kindly,
are you
on that single order?
Are you pressing this application or you are not pressing this application?
But
if you press, because you have challenged Mr. Mondal.
If your lordship directs, let that be a direction from the court that on the next date, the application for
not press this application. If you press at the same time, that direction cannot be passed, because those orders have been challenged here also.
Parent order is being challenged.
Yes.
All subsequent
and
order also.
That reconsideration is pending there. If you want reconsideration to be disposed of there, then you have to withdraw the civil division application. And if you want those to be taken on merits, then reconsideration cannot be decided. You have to choose between either of these two.
Let the trial court decide my reconsideration.
Then you are not pressing this.
Let that be a direction from the court, that the trial court must consider the application for reconsideration.
Are you pressing this
no, Lord,
on merits?
No, I'm not pressing it on merits. I'm not pressing
it. Have you taken instructions from your client? Otherwise, you will be in difficulty.
Then
otherwise, you will be in difficulty. Please take instructions that you are not pressing this. Then I can give you liberty, because you have challenged all these orders.
I shall take instruction.
After some argument, Mr. Mondal, learned advocate, and where is the first page of this order?
Lord, leave may be given so that I can type, Lord.
This is not the first page of that order, Mr.
Yes, Lord, 26th of March 2019 order.
Cannot be. This is the original copy. This is a photocopy.
No, Lord, a bunch of copies has been taken.
Sir, Mondal, what are you saying? Where is the first copy? This is the Xerox. Cannot be Xerox.
Since the overleaf, Lord, there is a seal of the the trial judge, Lord.
Sir, that is photocopy. Where is that original copy of this page? Please see this. This is a photocopy of that stamp.
Original to it. Certified copy of page Xerox certified copy.
This is not the copy. Where is the first page? The learned advocate for the petitioner
My lord,
Yes.
I am the petitioner, my lord. My lord, this application for expeditious, my lord.
Expeditious disposal of
Disposal of, my lord, my lord, my PR part, my lord, kindly, page number 10, my lord, maintenance case 106 of 2022,
maintenance case
number 806 of 2022, pending before the court of large
maintenance
judicial.
case under what provision?
227, my lord, kindly.
Maintenance case is under what provision?
My lord, 125 of CRPC.
Can it be under civil division jurisdiction?
My lord, kindly, my lord, under 227, my lord.
Can be done. Not in criminal divisional jurisdiction. Then the learned advocate appearing for
13 lawsuit, I am appearing for defendant number one petitioner, praying for expeditious disposal of the partition suit as well as pending application. Suit was 2018. Suit was thrice fixed for page board, but one plaintiff filed one application one after another and taken up this matter from page board. And lastly, 3 application was pending. 2 application filed by the plaintiff, 1 filed by the defendant.
Order 1, Rule 10.
Order 1, Rule 10, Order 6, Rule 17, and defendant filed application for maintainability.
Order 6, Rule 17 also.
Also,
that?
earlier also allowed.
So allowed, now it's not pending. Order 6, Rule 17 is not
No,
pending.
yes, another order 6, Rule 17 also pending
Copy served.
without any objection. It was reflected in order dated order number 48.
This application under Article 227 of the Constitution.
Lord, 14, I'm appearing on behalf of the petition, my lord.
Father opposite party, my lord.
My lord, what happened here, my
To
lord?
appear.
My lord, I made some error, my lord, in regard to the, my lord, averments as well as the annexes, my lord. Spraying my lord's liberty to, so that I could withdraw and file afresh, my lord. And my lord, one more prayer, my lord, so that I can get back the certified copy by replacing the photocopy of the certified copy, my lord.
Then, my lord, kindly direct them, my lord, to serve me a copy of the afresh copy that they will be filing.
After they will file.
After
My
they.
lord.
What is the error?
My lord,
My lord, in regard to the, my lord, I missed some annexures, my lord.
Annexures?
Annexures, I missed, my lord, and small error in the averment also, my lord.
What is the error in the averment?
I did not mention, my lord, about my lord, rent agreement, my lord, that I would to have indicated,
Lordship,
my lord.
kindly sees the order impugn, my lord. It is a detailed order. Mother is
Kindly
trying
allows
to
me, my lord, so I come
shift
back
the
to the
child
afresh, my
from
lord.
his original place of residence to on the guy of admitting him in a different school. When, my lord, in the present school, my lord, the child has the opportunity to stay with the mother and the father in the same apartment, in different premises, but in the same apartment. My lord, whether your lordship will give him the comfort or the, my lord, the blessings of both the parents. And this is the 4th round of litigation, my lord. The mother is making attempt to
Wants
shift.
to withdraw
My
because
lord,
he says
that's what, if
the learned advocate appearing for the
This is the certified copy. I took the leave to file without the certified. My lord,
The
in this matter,
certified copy,
subsequent
the
event.
certified copy of the
My defense witness, the matter after filing of this application, matter had been taken up on day-to-day basis, and on lastly, my argument has also been closed.
when argument has been closed.
On 10th of July. Those facts have been incorporated by me in a interlocutory application that has not been taken up today. So if your lordship kindly take up the matter tomorrow or direct the department to incorporate this say interlocutory application so that the
You have filed an interlocutory application?
Yes, already.
Do you have a copy of that?
Yes.
Please give me that. When have you filed?
Today morning.
কম্পিউটার থেকে ডাকিয়ে নিন তো, এটা ফাইল হয়ে গেছে, আনিয়ে নিন এটা। Can 1 of 2026.
My lord, this is a suit for recovery of possession and damages between plaintiff, between the landlord and the tenant. I am the tenant. My lord, kindly come to page 67.
Your evidence has been closed.
Evidence has.
Why?
My lord.
How many adjournments you took?
No. DW1 has been closed. After that, I applied for DW2, that is a bank manager witness. The bank manager was served the summons to witness on 18th of June. The matter was fixed on 22nd of June. The bank manager did not come up. So I sought for adjournment and sought for prayer for another, giving another opportunity to the bank manager to come. But
what is the dispute? What is the suit for?
It is a suit for recovery of possession. They are stating
what
that
the bank manager will do.
Yes, that is the case. It is the case of the plaintiff that I have deposited the rent directly in the bank account of the plaintiff. The plaintiff denying that fact. Now
you will be having your passbooks and statement of accounts which will
yes,
prove
that kindly come
for
to
that. What the bank manager will do?
My lord, that has been, my lord, kindly come to the deposition dated.
Yes.
Page 60. My lord, kindly take up my revisional application again, because I am relying upon the pages from my revisional application.
Yes, I am at the revisional application.
Kindly come to page 67.
67
of the revisional application.
Yes.
My lord, I deposited, tendered this my passbook that was turned down. Thereafter, I preferred an application to the bank manager at page 69. For statement, the bank manager issued this page 70. Bank manager issued the bank statement. That bank statement had been taken up with objection, stating the objection that kindly come to page 67, that it has not been certified by Bankers Book Evidence Act. So that's why, and it is the fact that under the unless the bank statement is being certified by Bankers Book Evidence Act, under the Bankers Book Evidence Act, that cannot be taken into evidence. So had
the plaint, please show me the plaint.
Yes, kindly come to page 14, and the relevant the issue that has been come up. My lord, kindly come to page 20, paragraph 10. May I read out?
This is a suit under the Premises Tenancy Act.
Yes.
West Bengal Premises Tenancy Act.
They want to prove that we are trespassers under 2G, but the original tenant died prior to the under the old act. So we have become the original tenant after by way of substitution. So that is the case.
Yes, so by way of these bank statements, what do you want to prove?
I want to prove that I deposited the amount to this to the plaintiff's bank account, and plaintiff is claiming that she has transferred it, returned it to me, but that has not been returned to me.
So, what the bank manager will prove this?
The bank statement, that is true, as because the bank manager, what has it is the fault on the part of the bank manager. The bank manager should have kindly come to page 70. The bank manager should have issued a certificate under the banker's book
But
evidence.
depositing rents in the rent controller.
After that, it is the question prior to that, prior to the filing of the suit. And unless a stay be granted, then I will win.
Can 1 of 2026 for stay?
Stay.
Why a different application for stay?
My lord, the subsequent, I have not here in the prayer, I have not separately prayed for any.
Oh, you have not prayed for stay.
That's why.
By the order impugned.
This application for custody by mother.
Application for
Custody by mother. The twin baby was left because she was kicked out from the matrimonial home. So aged 4.5 years.
child is with whom now?
Father.
Less than 5 years.
Less than 5 years. So twin baby, one girl child and male child. And what the visitation, instead of hearing the application, the learned court has granted visitation in the school where the child are reading.
Where is that order?
So kindly see the improved order.
Mr. Ghosh, transfer of custody at this stage may not be possible
Yes.
now.
But
But
your lordship, only one thing.
a visitation in a different place that can be considered.
Well, I think that if your lordship got some mandatory election, that matter can be disposed of because you know, it is hard.
Anyone appearing for the opposite party, you are appearing.
No. The motion, no KPA. I can serve Lord if your lordship.
But in the school, are you visiting the child?
Yes.
Only for 1 hour.
Only 1 hour, Monday and
Monday, only one.
Where are the parties residing now?
that is residing.
You are residing where?
At this Huldia.
How far is the distance between the residence of the?
Debra, I am residing in Debra.
How far are these two places?
And that is post office, Vikram police station, Debra. Both are the same police station. Mother and.
How far? How far? Distance?
That, maximum 4-5 miles, not within the same police station.
One 1:30 to 2:30 is the tiffin time. Tiffin break. Uh,
Your lordship will get.
9th of পরে
No, next page kindly come to next page.
27th March was for fixed for interim custody. What happened? That application has been heard.
No.
So, Ghosh, I think it would be better if that application is directed to be heard. Otherwise, it will get delayed.
No, that's why Lord, your either Lord, your lordship fixed date you can serve immediately, or Lord direct the learned district judge to immediately hear out the matter and
Yes,
by
I
the
think
next
that's
day.
better.
Yes.
Petition for interim custody, I think that's better. Otherwise, it will delay.
Yes.
And if it is pending here, nothing will be done
I
there.
know.
After some argument, Mr. Ghosh learned. Yes, next.
My lord, I am appealing for the petitioner.
Petitioner.
Yes, my lord.
Yes.
Suit was filed in the year 23, September 23. The defendant.
Expeditious disposal.
Yes, my lord.
What is the suit for?
Suit for recovery of balance consideration amount from the defendants. And my lord.
Money suit.
Money suit, yes, my lord.
Written statement filed.
Written statement was filed after expiry of 2
So
years.
it is fixed for acceptance of the written statement.
Yes, this
21st of December.
21st of December.
This application under article.
Kindly say, 3rd June 26 was the last date. And
Yes.
the written statement was filed in January, they appeared in January 24th and filed written statement in January 26th with show cause application. After 2 years, they filed written statement. After the case was suit was fixed for ex parte hearing, then they came up with the application and filed the returns. Every day they prayed for adjournment. Now this recalling application and is pending, show cause application is pending, and when we file the suit, we move the injunction application also.
Correct.
No order is there.
This
as to-
application under Article 220.
I am for the wife of the
Wife opposite party.
I am appearing for the petitioner, husband.
Yes. What is the application for?
My lord, this revisional application is directed against the impugned order dated 2nd June 2026, passed by the learned trial judge, first court, first additional district judge Alipur, my lord, and thereby directed the petitioner to pay alimony to the tune of rupees 55,000, that is 30,000 for the petitioner, for the opposite party wife, and 25,000 for the child, minor child. Now, in addition, 25,000 litigation. Now, my respectful submission, my lord, what happened? This is higher side, because your lordship kindly consider that the order shows that holding that the income of the petitioner, revisionist here and opposite party therein, that is 73,700. And the peculiarity of the case, my lord, both the petitioner and the opposite party are chartered accountant. Only difference is that the petitioner herein is in employment and the opposite party wife is running her own firm, my lord, chartered firm. But what happened? She took a plea that she is not doing anything. Now, question is, my lord, my submission before your lordship, that this is higher side, and not only that, from the date of filing means 2019. 2019 means, my lord, that time my salary as considered 73,000. This is a higher side, and I am ready to pay to the child, my lord. But that is why my respectful submission before your lordship, that is considering everything, reduce the amount so that the petitioner may survive. And on the other hand, the opposite party wife is from the family of diamond merchant. So this is the situation. I am in employment.
Where is the affidavit of assets and liabilities?
That is lying with the record, with the TCR.
Those have not been annexed with this petition.
But after going through the, here is, my lord, if your lordship permit me, huh?
Okay.
Please give me a
These
minute.
two assets liabilities, my lord. Both. And the opposite is professionally qualified chartered accountant. This is for the petitioner, my lord, and rest one for the wife.
Where is the income tax return?
ITR is there.
Income
ITR
tax return,
annex.
which page?
No, nahi. আমার কাছে আছে। I have annexed the ITR, man. না, পেজ মার্কিং নেই। 2012 after 3 years.
When the application was filed for alimony?
My lord, that is on 8th March 2019.
ইনকাম ট্যাক্স রিটার্নটা যে সাবমিট করি তার রিসিপ্ট আর আমরা ডিটেল ইনকাম ট্যাক্স আইটিআর দিয়েছি।
And wife did not furnish or disclose full annexures regarding the ITR, my lord. Only the acknowledgement.
Yes, what do you say?
Everything has been taken note of by the learned court while granting the maintenance in favor of the petitioner as a
Yes.
wife opposite party as well as the minor son.
Yes.
My son is a student of class 8. My son is a student of class 8. But
Son, he is ready and willing to
it is
pay.
fact I am a chartered account, but fact remains for taking care of my son I had to leave the job. At present I am totally unemployed. Totally unemployed.
Educated and professionally qualified.
What can be done? You have driven me out on the very immediately after marriage. I am taking care of my son. There is none in the family.
And
to take care
carrying
of.
Educated, unless you can prove her income.
No, my lord, even,
What can be done?
She is carrying COP,
Certificate of practice.
certificate of practice.
Your lordship submitted the standard of certificate before the chartered institute.
Where is that?
So this is her side, my lord.
Where is that? We have stated that she is carrying the certificate of practice.
COP. No, COP is carrying because she not denied that she is not chartered.
No. Certificate of practice. You have said
Because it is not her case, she surrendered the COP.
No, you have to make out a positive case. Negative cannot be proved. Please show me that you have stated that you are saying that she has having the certificate of practice. Where is that?
I
You
have
not
to
stated
inquire.
that.
I have to inquire.
So it's not your case. that-
However, my lord,
so
my
that's a
respectful
mere
submission.
statement from the bar. There is nothing on record with regard to this.
No,
That's
my
one
lord,
way
that
of-
I can place, my lord.
That's one way of looking at it. But the other thing is that even assuming She is having the certificate of practice. The question is income, which is to be proved. So
That cannot be
merely
assessed
by having a certificate of practice, it cannot be said she is not entitled to. You have to prove that what is her income.
Both were a student of CA, my lord, and not only that, she is senior than me.
I am not denying that.
That's
Yes, you
given.
have
That's
stated
neither
about
here nor there. And
Because she never disclosed in her assets liabilities. Rather, she claimed that yes, she is CA. And no bank statement, no ITR, accepting acknowledgement.
what is your yearly income? What is your yearly income? What is your present yearly income? What is the stage of the suit?
That is now suit is for framing of issue. Just because due to miscase, my lord, that was
I can do one thing, I can expedite the suit.
the one order sheet rule 17 petition is pending. That has
Order
been
sheet rule
filed.
17 is
Yes,
pending.
Yes, that has been filed by them. Salary has been recorded by the learned court 73,700 present.
You are in service.
I am in service
as
manager,
financial manager,
as senior manager, F&E, senior manager of the organization.
But it says manager contracts.
Yes.
You are not in a
High-Tech
financial.
System Limited, in the High-Tech System Limited.
manager contract.
At the time of filing, my lord, that time he was under contract. Now the senior manager.
What is your present annual income from salaries?
15 lakhs yearly.
15 lakhs.
From salary?
From salary.
Other sources?
Other sources I categorically mention in the assets liabilities, very little bit.
Very little? Not very little.
Pardon?
I've seen the income tax return, not very little.
Oh, but I disclose everything because other side not disclose.
And as an expert in accountancy, I've also gone through the income tax returns. So it's not little because from the income which has been disclosed from other sources, it shows the wealth he has. Some idea can be gathered from there. So that is what I'm asking you. It's not meager.
My only submission, I tried my level best to disclose everything before the honorable bench, but other side disclosed nothing, accepting the acknowledgement of ITR.
All right.
According to Rajnish,
it has to be hard. Ashun, please pay, and I will consider.
My lord, reduce the amount, my lord, and I am ready to pay.
For the timing, please pay. After
Higher
final year, it will be adjusted. After all, you are paying to your wife and child.
No, that is true, but professionally qualified and everything, my lord.
Please show me the law that professionally qualified is not entitled to any.
Qualified, obviously, this was chartered.
No, is not entitled to any alimony.
Whether
is not
no,
entitled.
I am not saying that, and I will not say that.
So it boils down to that. So it boils down to that.
Maybe my only submission.
It boils down to that because
my lord, it was not the duty of the trial judge to see that and presumption adverse that due to non-disclosure, non-disclosure.
I will consider that.
Non-disclosure of ITR in compliance with the apex court judgment, your lordship.
Yes, you have not filed your income
Nothing.
tax return.
My instruction, everything, whatever the documents are available, those are
nothing.
Have you filed your income tax return?
No ITR, nothing.
Challan was probably filed.
Only challan.
That challan was filed.
What challan? What is the challan?
Payment receipt. Payment receipt. ITR payment receipt.
Only challan, my lord.
ITR payment receipt means
That is
income tax you have paid.
Acknowledgement.
ITR
Acknowledgement. So where are
Barring
these supporting documents?
Those are
You are
not-
also a chartered accountant. So you know how to prepare an income tax return.
Because then that will came out from the
I
back,
asked
my
my
lord.
client to produce at the
Maybe
time of
window
final.
dressing by both. Accounts window dressing by both. That's understandable.
I gave
So,
everything.
but where is the supporting
I will ask
documents?
my client to produce all those papers at the time of final.
Now when? Because without considering those, my lord, this order,
After hearing the
one-sided order.
Sorry. ওই ফাইল করবো, ফাইল গুলো দিই।
এইগুলো ইয়েস
এটা আপনার
And for the petitioner, my lord.
in view of the aforesaid discussion, this court is on the list.
My lord, item number 19, I am for the plaintiff wife. I have prayed for expeditious disposal of matrimonial suit which is pending since 2021. In the year 2022, affidavit in chief has been completed. My lord, till the
You are the husband or the wife?
wife, my lord.
Wife.
Wife plaintiff.
Any alimony, order for alimony? No.
No, my lord. One application is pending under section 24 of Hindu Marriage Act, maintenance for minor child, which has been filed by husband.
It has been filed by the husband.
Yes, my lord.
Where
order
is that?
Order number 22.
Order number 22.
5th May 2025.
10th of June. It was fixed for hearing of the 30th of July. It is fixed.
Yes, my lord. 30th of July.
This application under Article 220.
No time limit.
Now the counter claim has been filed. What can be done? You have to file your written statement.
Well, this is the suit for partition.
Yes.
Preliminary degree has been part. Thereafter, the petitioner preferred an appeal before the learned judge HON'BLE, and along with the stay petition. Well, stay petition, since it is pending, kindly come to page 59, 13th October 2023. And thereafter, the learned trial court
The
fixed
application is pending.
My lord, the 13th, it was filed on 13th October 2023. Thereafter, learned trial court goes on the, my lord, the appeal itself. And I respond number 1, 2, 3, my lord, contesting respondent before the trial court. And respond number 4 to 15 is a pro forma respondent. The petitioner also filed an application order 6-70 for deleting the name of the respondent number 4 to 13, 15. And
You have filed that application.
my application before the trial court. Since it was pending, the learned trial court did not take up the stay petition before the learned judge. Kindly come to page 59.
Application filed.
Filed.
What is the suit for?
Suit for partition.
Appeal is against the preliminary degree or the final degree?
Final degree, preliminary degree. Final degree has not been drawn up.
Final degree has not been drawn up. So, what stay?
What stay, my lord? Otherwise, my lord,
what stay? Stay of what?
Stay of the, my lord, the preliminary degree. They have been, my lord, taking the petition pending before the trial court. My lord, that is a one after one. Mool, my lord, title appeal has not been heard out.
What is the stay you have paid for?
Stay for state paid for by the against the share of the property. My lord, they have been, my lord, sold by
the stay application. Have you annexed that?
I annexed. Kindly come to page 59.
59.
Partial partition has been made. They have not made the all entire suit property. Only particular dag number of the 228.
You have paid for adjournment. What can be done? Order dated 3rd of September 2025.
They have prayed for, they are not taking steps properly, so they have prayed for trial court. My lord, thereafter, my lord, the learned trial court did not take up this petition.
You have paid for time to file the amendment application.
No, they paid for only, my lord,
amendment is fixed for hearing when?
No, it was fixed for hearing 11th August 2026.
11th
August.
It has been fixed.
It has been fixed.
11th August 2026. This application under Article 227 of the Constitution
Petitioner Lordship, this application for expeditious hearing of the title suit number 138 of 2023 pending before the Civil Judge Senior Division at Durgapur, Lordship. Lordship, I am the defendant number 1 of this suit, Lordship, suit filed by the petition.
Suit is at the peremptory hearing stage.
Lordship.
Regular presiding officer is there.
Lordship, just join, Lordship.
Just joined.
Just join. Again, just join, Lordship.
Application under Order 6 Rule 17 is also pending.
Lordship, the application filed on 3rd of February 2021, Lordship. But
Please see the order date 18th of February 2026. Application under Order 6 Rule 17 is pending.
Lordship, kindly to then pass an order to expedite the matter and
This application under Article paying for adjournment, resolutions by the local bar association, what can be done? Yes. Yes.
This application has been filed challenging an order of rejection. My lord, if I may indicate the facts in a nutshell, the petitioner.
Rejection of what?
My lord, rejection of a section 151, which has been filed by the petitioners seeking to preserve and protect the estate of the deceased. My lord, the petitioner, my lord, if I may indicate the facts in a nutshell, my lord, the petitioner number 1 is the widow of the deceased. Petitioner number 2 is the minor daughter of the deceased. The opposite party number 1 is the mother of the deceased. My lord, the person died on 2019, leaving few insurance policies and some monies lying in the bank account worth roughly around 53 lakhs.
Yes.
My lord, thereafter I had filed a succession petition in order that the petitioner is entitled to 2/3 of the estate and the mother is entitled to 1/3. My lord, admittedly, the mother was the nominee in the insurance policies.
Mother was the nominee.
Mother was a nominee. She
Mother
has
is the opposite party number
1.
1. Yes.
My lord, she has received the entire money. My lord, thereafter I had filed an application before the learned court below, asking the court to direct the mother to deposit that sum in a
I'm not asking the money, asking the court to pay me the money, asking the court to deposit the sum in a escrow account or any joint account, my lord.
Who are the heirs?
My lord, the petitioners and the mother.
Petitioners and the mother. Mother is the opposite party number 1. Who is opposite party number 2?
My lord, the opposite party number 2 is the brother of the deceased. My lord,
he will not be entitled to.
my lord, he is not entitled because he
he
has withdrawn some sum from those bank accounts. That's why he was impleaded as one of the party in the main proceeding, my lord.
Oh, he is the account holder of the joint account where this money has been transferred.
My lord, he has withdrawn some money from some few accounts, my lord.
But are the accounts standing in the name of the opposite party number 2? Otherwise, how can he withdraw?
My lord, some was withdrawn beforehand, my lord.
How could it be if he was not an account holder?
But this entire proceeding is in respect of 3 insurance monies, my lord. If my lord takes up the schedule once, my lord, he was not a joint holder as per my instruction.
Give me a minute.
কেন শরৎকে কেন পার্টি করা হচ্ছে?
Final hearing has been fixed on 19th of August.
Well, the final hearing of the injunction application, my lord.
No.
Well, this application has been disposed of, my lord.
That application has been disposed of. 19th of August has been fixed for what? Final hearing of the succession case.
Hearing of the succession case.
Yes. So let it be disposed of because there are allegations and counter allegations.
My lord,
there are also allegations against you that you have withdrawn.
My lord, I have not withdrawn any money, my lord.
That cannot be.
My lord, that is not on record, my lord. I'll place the objection, my lord. If my lord takes up my petition, which is there on page number 145, my lord.
The ex parte order cannot be passed. If you want, I can direct you to serve. That will only delay the succession case. Or I can direct the succession case to be disposed of. It's fixed on 19th of August.
My lord, the assets needs to be protected, my lord. They are sitting with the money, my lord, and I am apprehending that they will misuse them and misuse the assets, my lord, of the deceased.
Except the insurance policies, what are the other?
There are some monies lying in the bank account. I am not seeking any order in respect of those.
Why? Bank account standing
but
in whose name?
My lord, in the name of the deceased only. But the main money is lying in the interest in the insurance is
who is the nominee
insurance
in that?
amount, my lord.
Who is the nominee in those bank accounts?
Bank account, my lord. They have not withdrawn the monies from the bank
nominee?
account.
Who is the nominee in those bank accounts?
Yes, a nominee. This I need to take instruction. Who is the nominee? If my lord takes up the schedule on page number 149 once.
149. Yes.
There's a sum of 53 lakhs 29,000. My lord, those LIC. There are 2 LICs and 1 life insurance, which makes up most of the amount, my lord. And they have admitted that they have withdrawn such money.
They were the nominee. They were
entitled. They were simply the custodian of that money.
Yes.
My lord, I am not asking the court, the honorable lower court, to give me that sum. The sum needs to be protected, my lord. It needs to be preserved. Well, to that effect, my lord, I have filed the application which is there on page number 145.
But that has been deposited in which account?
Well, this monies. from the withdrawn from the insurance companies. My lord, that
How much amount?
my lord, that I am not aware of. This
Then the injunction is to be made with regard to that. You are also not aware of that.
but my lord, they have admitted in the
Can a vague order of injunction can be passed? Please consider this. If someone is having an account, there is some balance. Now, according to you, X amount is being credited from the life insurance policy. They can be only restrained from withdrawing that X amount, not over and above that. You do not know the amount also.
my lord, the amounts which are indicated in page 149, my lord. 149.
Page
149. And if my lord takes up their objection once.
232 and this. And this is life insurance policies, this 1, 2, and 3.
Yes.
And what are the other amounts?
That are lying in the bank accounts, my lord.
What was your husband doing?
The husband passed away in 2019, my lord.
Yes, what was he doing during his lifetime?
He was running a business.
But this is the only assets which your husband had.
My lord, these are the only assets which the husband has.
Akiola, we should
And for the petition.
Yes.
Expeditious disposal Ekman suit, my lord, argument stage.
Argument stage, even then you have come.
My lord, 6, 7 months are gone. And this is a matter of a lawyer, my lord. Clearly see the epidemic.
For that you have come. The application under Even you have
But
judged
the
bench.
judge has changed. You
But
have
it has to
changed
be hard
with
afresh.
arguments. So that's why I submit my lord. It's
Uh,
argument stage.
What is the next date fixed?
And the next date is on 22nd July.
This application under Article 220.
Your Lordship, I am appearing on behalf of the plaintiff, Your Lordship. I am filing my affidavit of service, one kind indulgence. Your Lordship, kindly keep it tomorrow.
Why?
Your Lordship, I am led by Mr. Advocate Jishan Haq. He is on his way before Rajarhat Court. Your Lordship, kindly keep it tomorrow.
What is this matter?
This is a revision. This is a revision filed against the order dated 5th June,
Yes,
in
what
which
is
the
the nature of the
arbitration,
order?
yes, in which the execution was passed.
I will indicate. His facts are very heavy. He is a new entrant in the matter. My learned friend appears for a judgment debtor who has suffered an award of eviction, which has been confirmed right up to the Supreme Court. So pending execution, after he submits an affidavit that he is no longer in possession. So when the matter is fixed for delivery of possession, issuance of writ, he files a Section 47 application saying that he has filed a suit where he has challenged he is the sublessee of the property. Where in that suit, he is challenged the lease deed granted to me by my lessor after accepting me as his landlord. So that
I think a
section,
similar matter came up.
connected matter, Mr. Banerjee had moved.
Yes, Mr.
That was for
Siddhartha
one of
Banerjee has
yes,
moved.
that was for one of the subtenants. So he is the main tenant who is. But on affidavit, we were on caveat, copy was served yesterday night. So I have not been able to go through the entire papers, but there is an affidavit which categorically says that he is no longer in possession.
Your Lordship, the matter is fixed for hearing on 16. So that this matter can be heard tomorrow. It will
There's a
not
ploy
create any
is to keep
prejudice.
my execution pending. If he is not in possession, man, I can show it to your Lordship. It's on
That
affidavit.
is pending before the
Come at 2
title suit.
PM. Come at 2 PM.
Grateful.
Grateful.
Yes, call the Jalpaiguri matter. Please wait, there's a Jalpaiguri matter after that.
But in item number 2, can 9 of 2025. Well, this is a restoration application of petition number 2060 of 2022.
The filed a restoration application.
Yes, well, the only difficulty, I have a notification in my hand issued by the registered administration, which says that this application has been transferred to Jalpaiguri.
Application has been transferred to
But
Jalpaiguri.
this matter has been, well, the entire 1 and 2 both has been assigned to your lordship in April 2026. Well, in that even can 9 has to be brought in, or my lord, I can file.
Can 9 of 2025.
File.
You took can 9 of 2025 दुखाना कर. So that has to be brought from the and state is the where is this? Who is appearing for the state?
We have served copies on them, but prior to
GP. Oh, prior to that, this is what is the dispute?
Well, this is in relation to Boxer Tiger Reserve. Well, my clients are residents within the area, and they had been running the homestay. But the National Green Tribunal,
so you are in the WPA 2063.
2060 writ petitioners.
And who is in 2328?
2328, I think, another application that has been filed by some other.
Who is the writ petitioner?
Some other writ petitioner. Mr. Sami Mohammed has been appearing on their behalf.
Where is Mr. Sami Mohammed?
Well, sent for him, well, the only difficulty is this. Well, the order that we have challenged by the passed by the National Green Tribunal, we were not heard, but the order in effect passed against us. Number 1. Number 2, my lord, we have taken a point that the Green Tribunal, while passing the order, was coram non judice. The tribunal formation of the tribunal dehodes the National Green Tribunal Act, and based on that, an interim order was passed in our favor.
But now your writ petition has been dismissed for default.
My lord. But the difficulty is the first writ petitioner who has been entrusted by other writ petitioners to look into the matters and who has been dealing with on behalf of them. Well, unfortunately, he committed suicide sometime in 2025. So, rest of the writ petitions, they are required to accumulate the papers once again. And I had no instruction, my lord. I could not appear, and the advocate who was appearing in this matter, he could not reach.
But do you have any idea after the change of panel who is appearing for the state in this type of matters?
No, I do not have. Well, if my lord directs me to serve,
You have also not served after the change of panel.
There is a 10 volumes of the writ petition. My clients are really poor residents of that area.
But the copies has to be served now. The panel has
can't be
changed.
leave to serve electronic copies. Kindly can't be leave to serve electronic copies.
Electronic copy. Let them appear unless they appear.
Very well. Very well.
The learned advocate appearing for the Yes.
But just two facts before my learned friend starts, because that fact is suppressed over here.
What fact has been suppressed?
That he is not in possession, which he has stated on an affidavit before the executing court. And he is also not disclosed the entirety of my affidavit in opposition to his Section 47 application, which contains all the annexures through which I could demolish his case.
Your Lordship, kindly keep it tomorrow as there is no senior today, Your Lordship. It would be prejudicial to our client. Your Lordship, kindly, if you see point number 15.
And I'm sorry, I will indicate what it kindly comes to page 3 of the affidavit I have handed over.
Page 3 of the affidavit.
Yes, I just handed over a affidavit Dilam. This is an affidavit filed in the execution proceedings after the SLP before the Supreme Court was dismissed. I'll also show that order. And kindly comes to page 3, page 2, paragraph 3. The list of dates is set out here. Special officer is in possession, see the symbolic possession of the property. When it kindly comes to page 3, where the table ends, therefore it is amply clear the Star Trek is no longer in possession of the subject premises. I state on perusal of the various reports by the special officer, in the next paragraph, my lord, occupants found to be in occupation various subject premises, it can be verified the respondent company has not been in possession of any part of the said premises since as long back as 2016. Lord, after saying this, if I take your lordship to the prayers in the section 47 application, where he is only challenging that the possession should not be delivered to me, what remains in his section 47 application? And this vital fact is not even mentioned, and the learned judge has observed it in her order.
Sir, Your Lordship, I'll indicate only one paragraph at page number 15 of my application, Your Lordship. Point number.
What is the order under challenge?
Dismissal of his application under section 47.
What is the order number? Dismissal of his application under 47.
Yes.
Your Lordship, in the title suit, they have filed an section under 151, which got rejected by the same court. The order date was June 11, 2026.
When it comes to page 45,
I'll indicate only
first
this
volume.
point, Your
The
Lordship.
order dated 5th of June 2026.
We have challenged that order, Your
It's at
Lordship.
page 45 of the first volume.
Your Lordship, we are challenging that order itself.
Kindly
Yes, you are challenging the order dated 5th of June.
Yes, Your Lordship. And subsequently on June 11, the same court dismissed their section 151 application, saying that it is a tribal issue. We have challenged the foundational lease deed, Your Lordship.
Page 55. But the operative portion starts from page 55. There's another fact which will have grave bearing. The land belongs to KOPT. It was leased to me pursuant to an order of the Supreme Court. Prior to that, I had given a license inducting my learned friend as a licensee in the property. He admits me as his landlord, pays me rent, then challenges my title. And the suit that my learned friend is referring to questions the lease deed granted to me by the Kolkata Port Trust.
So before that suit is decided, if the arbitration proceedings proceed with the execution, it
What
will be
happened on
prejudicial.
11th of June 2026?
So, Your Lordship,
Time
on
was
that day,
separate for
their application for under section 151 got dismissed because the learned judge made the issue tribal. So if the lease deed, the foundational lease deed is under challenge, Your Lordship, now if that particular title suit is not adjudicated at first instance, the execution before the arbitration would be prejudicial to us.
All right, I'm keeping it tomorrow
Much
on the prayer of the learned advocate for the
Your Lordship, just want indulgence. I want to submit the affidavit of service, Your Lordship.
Sir, yes, file it. Every service taken on record করে দিন. Yes.
Much obliged, Your Honor.
Item 26, I'm appearing for the petitioner.
Yes.
Well, this is in relation to an order which has been passed holding that the stay that was granted in an appeal has stood
8th of June.
Yes, has stood vacated on account of non-compliance. Your Lordship, before I take my lord
What is the non-compliance?
my lord, may I just indicate, I hand over a copy of the main order of stay, my lord. To the my lord kindly takes up this order of 8th of May. Here the title appeal was being heard, and my lord kindly comes to the bottom portion of the order. There was a direction that the operation and judgment of 25th September 2025 passed an ejectment suit hereby state for the period of 8 weeks till disposal of the appeal, and whichever is earlier subject to payment of occupational charges with effect from January 2026. The appellant shall go on paying current occupational charges for the subsequent month within 7th of next English calendar month, and by way of demand draft in favor of the respondent or by court deposit. The arrears of calculated amount of occupational charges is to be paid from the month of January to April by two equal installments within 30th of June 2026 or before the disposal of the appeal, whichever is earlier. It is made clear that if the appellant fails to make payment of the current as well as the arrear occupational charges as calculated by this court within the time mentioned herein before, the stay granted by this court shall be automatically vacated. So this was the condition. Your Lordship, on 8th May, this order is passed. On 21st May, I prepare a demand draft where I'm supposed to pay 3,000 per month. I have prepared a demand draft of 12,000 because now there were 4 months due. I have to pay 2 months, and before the 7th of the next month, I have to pay another 3,000. Instead of that, what I have done is I've prepared a 12,000 demand draft, and on 25th, I try to serve the demand draft on the particular party, the opposite party. He does not receive it. On 8th, I again try to serve it on the party. He does not receive it. I have gone to his house. I take photographs that he did not receive, and the matter was returnable on 10th of June. On 10th of June, I deposit the entire demand draft with the court because there is a direction that I can deposit by way of demand draft. This
10th of June.
On 10th of June. The 10th of June order is also, Your Lordship. On 10th of June, at this stage, the learned advocate on behalf of the applicant files an application along with demand draft dated 21st May 2026 to the amount of rupees 12,000. In the application, it is stated that the appellant approached the respondent to hand over the demand draft, but it was refused. On the other hand, the respondent raises objection and prays to file their written objection against the application, and thereafter the learned court transfers the matter to a different bench for hearing of the appeal. On 22nd, when I appear before the court, there is a direction for it to appear on 22nd. When I appear before the court keeps it on 30th. The transferee court keeps it on 30th for hearing the matter, because that was the last date in terms of this 8th May order, where I had to comply with payment of 2 installments and also pay the current charges. Your Lordship, in the meantime, when on 22nd as well, they did not receive my demand draft. I had carried 2 more demand draft of 3,000 each, and this was also placed before the court on 22nd. When they did not receive these demand drafts, on 25th, I have made court deposit. I shall show Your Lordship all the documents. They are annexed. The other documents are all annexed. The payments I will show. And I place before the court that because of this demand draft, it would relate, the payment would actually relate back to the date of issuance of the demand draft, because I have already kept aside some amount and I have tried to tender. At best, I had tendered.
Keep the demand draft with you for 3 months.
No, Your Lordship,
tender.
I have tendered it on 10th.
Unless you pay the amount, demand draft tender to the other side, how does it amount to tendering?
Your Lordship, I was supposed to, I have
Sir,
made an attempt. In the meantime, there were two dates of vacation. From 22nd, the vacation had started.
in the executing court.
The date fixed on 29th July. There again, I have filed an application under section 47 because the suit.
29th of July.
Yes.
Where are the parties?
There's only one landlord.
City Civil Court.
City Civil Court within jurisdiction.
Who is the learned advocate appearing in the City Civil Court?
Other side. I know him by face.
Can you bring him? I'm
I-
passing it over.
Well, I will try, my lord. Otherwise, my lord keeps it tomorrow. I will. He generally is around courtroom 11. I have found him.
All right,
Otherwise, my lord keeps it tomorrow. I'll try to serve and come back.
The petitioner is directed to serve a copy of this civil division application upon the learned advocate representing the opposite party before the first appellate court.
Tomorrow, my lord. Same matter, two different premises. 26
Same order.
and 27.
27 or same order?
Okay.
My lord, let me appear on behalf of the defendant. Defendant is before your lordship. This is, my lord, against the order allowing an amendment application.
Allowing amendment of
the plaint, because they're trying to incorporate, my lord, 2G. Initially suit filed for the ejectment.
Cannot be done.
Calcutta High Court decision is here, but it cannot
be done.
And one point, another point is that my lord, tenancy has been created much prior to, my lord, coming into the force of the night.
That's on facts.
That's on facts. Because one hand, they are, my lord, seeking, my lord, decree under section 6, and another hand they are saying, my lord, I am trespasser. That will, my lord, change the, my lord, nature of the suit. Paragraph 30 is, my lord.
You have cited this judgment.
The judgment was not
So
cited.
some judgment was
Cited, that is my regarding my,
2023 one ICC. What is that?
that is for my lord, I think my lord, for introduction of the new facts.
Do you have that
General,
copy of that judgment 2023 too?
that was not cited.
No, yes, it was referred to. The learned advocate for the plaintiff
Let me,
cited.
sorry,
Where is
let me
that?
check it.
There are two decisions. 2023 1 ICC 961, 2023 2 ICC 237.
I have a copy of that, my lord. পাঠিয়েছিল 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 সম্ভবত।
Is the defendant, my lord. Plaintiff opposite party, my lord, has.
What is the order under challenge?
My order has been challenged, my lord, against the page order dated, my lord, 2nd April 2026. And wherein, my lord, learned trial court has directed, my lord, to pay the, my lord, area rent, my lord, since 2022. But it has been detected that, my lord, plaintiff opposite party has been on the letter of adjournment. He has been informed me that on the basis of registered gift deed, he has been the letter of adjournment dated 16th February 2027 and registered deed on 2006. So it should be 2006, my lord. Otherwise, my lord, it should be harmful to the petition.
I could not follow your submission. Please give me a minute.
Yes, ma'am. Page 43, my lord, 72 petition, my lord, that should be looked into. Paragraph 12.
Page
43, my lord, 72 application, paragraph 12, my lord. There is specifically stated, my lord. Learned trial court has failed to appreciate that.
Where is the written objection to this application?
Yes, my lord. Just.
Yes.
It is started page 47.
When they purchased?
2006, he has gift deed. On the basis of gift deed, one letter of adjournment is there, my lord. They have informed, my lord.
Where is the letter of adjournment?
Yes, my lord. This letter I have kept leave, my lord, in this application. Just kindly see for a minute. And that document has been evident, my lord. I am.
No,
The kindly page 54, my lord, this document has been evident. Kindly
you are the tenant under whom?
Now, my lord, as per my lord, his registered deed, my lord, Gautam.
No, you are
my father was the tenant, my lord, previous.
Under whom?
But the mother of the firstly, the Devnarayan Thakur was the tenant of Narayan Chandra Pal, the predecessor of the
Devnarayan Thakur was the
my father, my lord, our father.
Yes.
He was a original owner
under Ashutosh Pal.
Under Narayan Chandra Pal, then Ashutosh Pal. After that, Ashutosh Pal's wife, my lord, Durga Rani Pal. After Durga Rani Pal gifted the property to the opposite party, Gautam Pal.
Yes.
He given me letter of adjournment on the basis of that adjournment. After that, he filed suit. So on that respect, my lord, he has to get my lord 2006, my lord, as his registered deed is stated in his adjournment letter, my lord, as per registered gift deed. So this. Page 54, kindly see the documents has been submitted, my lord, wherein document.
Any copy of the gift deed was given to you?
They have informed, my lord. No gift deed is given me. As per atonement letter, my lord, they have informed on the basis of gift deed, he is now the owner of the property.
Thereafter, the suit was filed.
Thereafter, suit was filed. And page 54, my lord, the document has been submitted before the trial court, my lord, that has been evidence. I had received a letter from Gautam Pal to the effect that he has become the owner of the suit premises. Case 54, my lord. Learned trial court should have, my lord, from this 2006, my lord, it should be better, my lord.
The learned advocate appearing for the petitioner.
And opposing this application. Along with the Lord, Lord, kindly see, Lord, by the impugned order, the reference court, Lord, has directed to release 25% of the total awarded amount in favor of the.
Where is the impugned order?
Lord, volume 2, Lord, kindly see.
Nowadays, it's very difficult to find out the impugned order.
Lord,
Where it is not been annexed.
yes, Lord, page 243.
You have not filed the certified copy, Mr. Ghosh?
243. Lord, with leave, it has been.
You have not obtained the certified copy.
10th July, order of 10th July.
10th July.
Lord, page 243. Second volume.
Page 243. Yes. What is this?
Lord, what happened, Lord, the Honorable Apex Court, Lord, your Lordship will get that at page.
What is the impugned order?
This is the impugned order.
No, no. What is the nature of the impugned order?
Impugned order, by impugned order, Lord, in terms of direction of the Honorable Apex Court, the learned court below, Lord, the time limit was 7 days from the date of the order to release 25% of the awarded amount in favor of the respondents number 72. Okay. Lord, it was just Lord, 42.
Yes.
4 to 7. 25% within 7 days from the date of the order. Lord, your lordship kindly see, and the other applications for apportionment, Lord, time limit was given 3 weeks. 3 weeks.
Apportion, what was the suit for?
Lord, it is a reference, reference.
Land acquisition.
Land acquisition. What happened, Lord? After 3 weeks, matter was heard. All the documents have been taken into account, but
State is also a party.
State, no.
Yes.
Yes, state is a party. But my lord, the only thing.
State is not the affected party.
Yes, affected. There is no direction upon the state. Here, my lord, can you see the order passed by the Honorable Apex Court? It is at page.
Hearing of.
Should I interrupt it or afterwards?
Lord, your lordship, just see.
Preliminary objection.
Lord, page 115.
Lordship.
Page 115, the Honorable Apex Court's order. 115. Yes. By that order, Lord, matter can be simplified. That 3 weeks, when 3 weeks appeal.
What happened? There was a reference under section 18.
Yes. Lord, Honorable Apex Court, Lord, instead of appointed an arbitrator to decide the quantum of compensation. Arbitrator decided it. It was reference in the before the reference court. It was there, Lord. State being aggrieved by that order, moved the Honorable Apex Court. The Apex Court, Lord, on an application made by my client, directed him to file appropriate application before the reference court for apportionment of his share. Lord, then, Lord, the other side, Lord.
With regard to the apportionment between your client and.
Yes. Now this is the dispute. Lord, it can be simplified. What happened, Lord? Within 7 weeks, or within 7 days, 25% was directed to be paid to the opposite parties number 4 to 7 by the Honorable Apex Court. Lord, and further direction was that within 3 weeks, so far apportionment is concerned, that would be decided. Subject to their undertaking that in case it is found that they have been paid excess, they will return it. This is the order. Lord, your lordship will see.
Then what happened?
So then, Lord, order was passed on 15th of June. Lord, 7 days will elapse on 22nd. But the 23rd, they made an application that we should be paid in terms of direction. Ultimately, the matter was heard after 3 weeks. The learned court below, Lord, should have decided the entire matter and then released. He, instead of complied with the 7 days after 3 weeks, and so far our claim is concerned, has not been decided.
Has not been decided?
No. Lord, can't you see the impugned order? Lord, your lordship, kindly come to page 250.
Yes, please give me a minute.
Second last.
First, please take your seat.
Yes.
Please take your seat. Yes, yes, Mr. Ghosh.
Our difference is not that they have given undertaking in terms of the Honorable Apex Court's order. Lord, the learned court below has discussed everything what is, but within
there was a direction by the Honorable Supreme Court to release 25% and they have to give their undertaking before the court. Now, with regard to the
apportionment and other entitlement,
yes, the
that has not been
court
done.
was directed to decide.
Yes.
So there are various parties who are coming up. So that has to be decided. So the court has fixed that application under whatever rule 10, it will be decided. 25% the Honorable Supreme Court has directed to be paid to them.
That's why, Lord, I am telling, I cannot say anything regarding Supreme Court. That direction is there. At the same time, 3 weeks time was given to do it.
3 weeks,
Lord,
Mr.
if
Ghosh,
Lord,
now
7 weeks, 7 days is mandatory. Why 3 weeks is not mandatory? That's why, Lord, I am praying.
Mandatory is
Lord,
one
only
thing,
thing
but
I am praying.
now so many persons are coming up with claims. So the application under Order 1 Rule 10(2) has to be first decided. Then your claims will
That's
be.
why, Lord, I am telling only thing, Lord. Your Lordship can direct the court below to decide the matter within a specific time limit. Because 3 weeks have elapsed as directed by the Honorable.
Yes. What do you say? That can be directed.
This is not for any suit, my lord, neither it's a reference. What happened? State took over some land, made construction there, made a children's park without any acquisition or requisition proceeding. I challenged before this honorable court, learned single judge said there was no proceeding, requisition, acquisition, nothing, no compensation paid. So this is recording of bad. If the state wants, they can acquire it. State went in appeal. Appeal court also upheld that. From that, state went to Supreme Court. Supreme Court, the matter is pending for 30 years. So what we are doing by consent of part, we are appointing an arbitrator. The arbitrator will pass an award. And logically
fixing the compensation. Determining the compensation.
And if logic takes that order, that Supreme Court order, first order, starts at page 53.
Only 53.
Page only 53.
Yes.
Act page 59, paragraph 13.
53 is the order of a coordinate bench.
53 is the order by the Supreme Court. আমার পৃষ্ঠা জজের পৃষ্ঠা মিলছে না 55 I'm sorry.
Yes,
55. These are so at page 59, paragraph 13. At paragraph 13.
Paragraph
13.
Yes.
The learned arbitrator, I'm not reading the other portion, shall make an endeavor to pass the award as early as possible, but not later than 6 months from the date of this order. The aggrieved party shall be at liberty to avail its remedy in accordance with the provisions of the Arbitration Conciliation Act 1996, if so advised. So it was not a reference. Award passed, state prefers section 34 Arbitration Act application. In the section 34 application, the learned single judge passed the order in accordance with the direction by the Supreme Court. My learned friend has been locus, he was not a party to arbitration. He was not a party to award. What locus can he have? In arbitration, third party is not a suit. It's not a partition suit or a reference as such. And Supreme clearly said that the Provisional Arbitration Conciliation Act, and it is also evident from his pleading. My lord, can you look at his pleading at paragraph 3 of the petition?
We have been added. And other features.
Sir Ghosh, I will come back to you.
Page 5. Lordship. An impugn order, Lordship also, I mean, if Lordship see that paragraph.
Yes.
Page 5, paragraph 3.
Of the civil division
Petition, civil division. He is pleading. The petitioner states, Page 5, paragraph 3.
Page 5.
5, paragraph 3.
Yes.
The petitioner says no appeal lies against the impugned order, interlocutory order under section 37 of the arbitration conciliation. He is aware this is an arbitration proceeding and he was not a party to the award. Well, I need not cite any cases that in an section 34, a third party or stranger cannot come in or can challenge any order passed under in a proceeding under section 34. Apart from that, if Lordship takes up page 115.
2013 Act to din to.
My lord, so far as the consideration of his part, Lordship. Lordship looking for the equivalent section to section 9 of apportionment interested parties. Lordship.
Only one thing, instead of going through the procedures under the relevant acquisition act, an arbitrator was appointed.
And court say
was only,
Arbitration Act 1996 will apply.
yes, arbitrator was appointed to determine the compensation.
Right.
So compensation will be determined on the
Under
market
2013 Act.
2013 Act, section 26. That will be determined according to those relevant considerations has to be taken.
Now, without prejudice to
question
my
is-
rights and contentions, my lord.
Then the question is, an award has to be passed.
Award has been passed.
Yes. Now the award will pass in whose favor?
It's passed in my favor. Because I have been
Then if
contesting
there
for
is a
last 30
dispute-
years.
If there is a dispute, what will happen then?
My lord, they'll file a suit against me asking for a share of that compensation.
Under what provision?
Under the general law, because Lordship knows, even if I'm a nominee of the bank,
Say
in a
award, that award cannot be challenged because that award says X is the awardee.
Lordship.
X is the awardee. Nobody else are entitled to.
This is
So
very
you cannot challenge by way of a suit, and if you have to challenge that award,
no,
so-
not that award can be challenged by a suit, but if any amount paid to me, that he can challenge, he can claim.
he will be, if any person is aggrieved by that award, where is his remedy?
My lord, at least Supreme Court orders, I have the entire bunch with me.
I'm asking you, please enlighten me on this. Where to be, if a person,
Lordship.
there are two ways of looking at it.
Lordship.
One is an award has been declared. Pursuant to an order passed by the Supreme Court, and it says that an award is subject to the provisions of the Arbitration and Conciliation Act.
Lordship.
So now, let us assume X amount has been determined as the compensation amount, either of the parties, the state or you, who are the party before the proceedings, were aggrieved. Yes, 34. It's one way. Now, award has been declared only against or in your favor.
Lordship.
Mr. Y comes and says, no, not only X, I am also entitled to that share. Now, where he has to go? He is not a party to that arbitration proceedings.
Lordship.
So then, is it binding upon him? That award?
Lordship, if looks at their order of 15th June, my learned friend was relying upon.
Yes.
I think some answer can be found there.
Yes.
It was modified at page 115.
115.
Lordship. This is the last order by Supreme Court.
Yes.
And if your lordship takes up from paragraph 4.
The judgment.
Only the Supreme Court judgment.
All right.
Here. Now, in paragraph 7, set out of
7.
order dated 30th August. Set out. Lordship got it.
Page
117. Paragraph 4.
Yes.
In that earlier order 30th August 24, paragraph 7 is set out. If the applicant Sunya Anchali, the petitioner here, has any grievance, he may seek appropriate relief before the reference court. In case the reference court is satisfied that his claim is not maintainable, the compensation amount so awarded by the arbiter shall be released forthwith to the respondents in accordance with law. In case the party raise any other trivial issue, the reference court will resolve the same in accordance with law. After this, if lordship takes up paragraph 7 of same judgment.
Who is the reference court?
The section 34 court.
There is a nomenclature.
There is a nomenclature used by Supreme Court. কত গন্ডগোল সুপ্রিম কোর্টে পাকায় if lordship paragraph 7.
So if that is clarified, so then he has a right before that court.
Lordship.
You are saying
paragraph
he
7.
is not a party to that. He cannot go before that. That cannot be done.
Lordship, I let us put it aside. Lordship, look at 7. Further right has been created. Paragraph 7. Paragraph 7 at page 118. 3 directions, ultimate directions by Supreme Court. Reference court directed to release 25% of the deposit amount in favor of the
one thing, Mr. Sarkar, reference court, you are saying that section 34. Where do you get that? Section 34 is the reference court.
The orders will also be showing
30th of August. Which page? Bunch.
Yes.
30th of August is page 11 to 12 is that running page.
1.
30th of August.
No.
9 to 10.
9 to 10.
Page 9, my lord, your lordship, got it? Of the compilation.
Yes, yes.
30th August.
30th of
August.
Yes.
24.
Page 9. We inform that arbitration proceedings have been concluded and award is likely to be passed. At this juncture, moved by Anchalia, co-owner of Aquadas, seeking apportionment of the compensation. So he went before Supreme Court. Already filed seeking a declaration payment. We have heard we find no ground to either modify or further clarify the order 19 February 24. Ex-state government is right to deposit the amount, so and so. And 7, which I have just now I have placed for lordship. This was set out in the 15th June 2026 order. If he has a right, he will. That's why I'm placing my page 118. Page 118 is very clear.
34 or reference court under the act.
That is their prayer.
But here in this order, it does not mean that reference court is section 34.
This is the prayer made by them before the order. This of which this 30th August order was passed.
Which other can name? Other section, other application. Stated section 34 টা আছে না?
Yes. So they have sought for a reference for apportionment to a reference court under section 76.
That was rejected. কেন ওটা তুলে দিলি? কেন তুলে দিলি? আর confusion. আর দরকার নেই. This order is very clear. I think lordship need not look into all these things. He has been given a right.
No, so this application was made, prayer was made, and on that this order has been passed. It says reference court. It does not clarify that 34.
15th June also, man.
15th of. No, I only want to get it clarified. Where does it say this reference court is section 34 code and not the reference court under the 2013 Act? Page 20 of this compilation.
Where is that? No, no, no. This is the only proceeding pending. Section 34 application filed by state, and in that my learned friend has given a right. Lordship, that's what I am placing. Lordship need not time being ignore my submission section 34. No, Dorkan should just page 118, paragraph 7.
Paragraph 7 blood is
Yes,
clarified.
yes.
But this-
Paragraph 7, page 118 of the
Page
petition
118 of the petition.
by Supreme Court. There are three directions. One, to release.
Supreme Court has made this code, the section 34 code as reference code. He has been directed to release 25% in favor of the
Page 100,
118.
118.
Yes.
Paragraph 7I.
7I, the reference code
Yes. According to the
directed to release. Who went before the reference court?
State. By OFF section 34 application. Because Supreme Court said they can take recourse under 96 Act.
So,
III will be relevant for my learned friend.
so reference court, that court has been directed to decide this dispute as to the apportionment.
Apportionment.
So then you cannot take the plea that he not being a party.
I'm
to
not
the-
taking. I'm not
Here
taking.
is that blood
So
when
lordship can
directly
direct
there.
the lower court to decide it.
Yes. That's why I'm telling you. Within a specific time period. So that there is
And
no
25% cannot be touched according to Supreme Court. It has been given.
They have given
So the
undertaking, we cannot-
III let the lower court decide. And one more thing is, they have not filed any claim before the court below.
Well, according to us, they are only entitled to 20% because 5 groups.
That is to be adjudicated, of course.
But can any one of you call Mr. Nilanjan Bhattacharya?
Nilanjan.
Because the state is a party because that
between the private parties. This is a portion between private parties.
But
State will not have much to say. Subject to
State challenge the amount.
proceedings is by the state.
Yes.
And proceedings is by the state.
State has already deposited the amount.
Only the release of 25, nothing as per the Supreme Court.
As per undertaking.
The impugn order is releasing 25% according to Supreme Court direction. In my respectful submission,
That has been done.
that has learned friend cannot object. So far as question is
25%
deciding,
that has been done.
that has been done.
We have not received.
So lordship can direct to release it forthwith.
No, you have not come. You have not challenged this.
Yes.
Who has challenged?
সেটাই চ্যালেঞ্জ করছি ওরা দেবে না সেই জন্য চ্যালেঞ্জ করেছি
Their case is, they actually want modification of this direction by Supreme Court.
that can't be done though it has been couched in such language that can't be done my lord.
What is your prayer?
Yes,
Where is
I have
that?
seen, I have
Yes.
seen, I have seen.
Yes.
But my lord, our only grievance, my lord, the 3 weeks have elapsed. Therefore, he should have
So
decided.
Ghosti, now how many claimants have now come till date?
About maybe
4,
8, 10, 8, 10.
total 5 groups, 1 group is there, and 4 groups are there.
Total 5 groups. And within 5, how many?
All of them jointly, my lord, made application.
No.
Lord, 5 groups have made application. 1 has been allowed. So far, we are concerned. Our addition.
There are no. Circus is one group.
Yes, we are.
You are another group.
And there are
So another 3 left or 4 left?
3.
Another in total 5.
Total 5.
5 now.
Who is the majority shareholder?
We have 5 or 4.
No, 5 you may have 5%.
No,
He may have the balance.
Then equal share.
5, 25%. He may have 75%.
Co-sharer.
Co-sharers may have different shares.
No, 5 brothers. Equal share.
Where do I get the facts? The facts, where do I get this?
My lord, the 15th June order, my lord, gives the entire facts.
15th
At
June,
page
which
115. Of
The impugned order.
Supreme Court.
115.
That gives the
Page.
115.
115.
That's the last order, and that gives the entire facts.
The order
The Lordship may kindly allow me to um, may I appreciate Lordship couple of things, Lord. I represent other branches of the family, Lord.
Extend it.
Lord, next date is 6th on 17th.
My Lord,
Three learned court.
17th of
17th of August. No, no, it's
the learned advocate appearing for the
Lot of documents have been annexed before Lordship
where
in this civil division application. No claim application and these documents have been filed before the court below. Let them file a application. I should be given liberty to file a written objection to that, and then the matter will be heard. Let them file all documents together.
Mr. Ghosh, you have to file a
Yeah,
claim.
five documents are there.
No.
Give them a copies.
We shall give.
Give them copies.
Copy
You
of
have to
Will not
file a
fix any date
claim.
from here. Make that prayer there.
Yes. Copy has been given.
My lord, the amount may be directed to be released forthwith. The amount
Would your
should be
Lordship
that
kindly
25%
allow
should
me
be
1
directed
minute?
to release forthwith. My lord.
The direction is there.
Of course,
I have
but
not said that.
that it should be released as a, because they have made a challenge. They made an application there that this release.
It is however made clear that now you will make submission.
No, I'm for the.
Who are you?
For the
other applications under order 110.
They are not even a
One
party here.
Online, Lordship, I am for the other party. Lordship, my learned senior friend has agreed that we have our right to enter right now.
No, no,
That
no,
the
no. I have
next-
not said so.
No, no,
He
I
has agreed.
No,
my
no.
learned
He has
senior
not agreed.
Those are
He has
pending.
disputed. That's your
My
supporting
right has been
supporting
disputed,
advocate
but-
has said.
My right has been disputed, but I may be added and then it may be decided.
That whatever it is.
We are the branches of the same five brothers.
We have been already added.
Would your lordship branch is added? The other branch is automatically.
Second, lordship, I represent some of the family.
Yes, yes. You have not yet been added in the miscellaneous.
That is why, my lord, lordship will
Text test.
consent let we may be added. My lord.
Consent.
They have to, lordship. They have not.
Do that there.
If one of the branch is added,
Do that there. Yes. Consent, no consent, contest, everything there.
I'm great.
What are the একটা দেখে দিন number 31 yes yes
31, my lord. I am appearing on behalf of the petitioner, my lord. The suit for eviction. I am the tenant. My lord, there are three tenants. But it's a joint tenant.
What is the impugned order?
The order 22 rule 4 has been filed by the plaintiff. It was disposed of because it was beyond 90 days. That is why the name was struck down. Claiming because it is a joint tenancy. There is no.
I could not follow.
My lord, the plaintiff has filed the suit against three defendants. During the pendency of the suit, one defendant died. They have filed one application, order 22 rule 4 by the plaintiff. Plaintiff filed 22 rule 4 application praying for substitution of the deceased defendants of the heirs. But the application was beyond 90 days. The application which was filed under order 22 rule 4 is beyond 90 days.
That has been allowed.
No, that has been allowed with the observation that the name has only been struck down. Says because this is a joint tenancy, that is why the substitution is not required, only the name was deleted.
Only the name was deleted
of the deceased defendant in the order 22 rule 4 application.
Where is the application?
Yes, madam. Page 109, madam. Now, my lord will get the main part in page number 110. There is a prayer of substitution, my lord.
Yes, and what is your case? What is your objection to this?
Well, in my case, my lord, that they have made the application for substitution of the heirs. My lord,
Where is the original? What is your case in the are the joint tenants? Who was the original tenant?
Well, these three brothers are the original tenant. There is no dispute at all. I totally
Then it's a
agree.
case of joint tenancy.
I
So there is no case of
I absolutely agree with you, my lord. But my lord, there is one thing. My lord,
substitution and deletion made.
my lord, kindly hear me. 1 minute, my lord. My lord, there are three tenants. One of the tenant died. They have made the application for substitution. But my point, for the interest of justice, if my name will not be added, suppose during the pendency of the suit, these two brothers have made the default, or they did not take any step, and the suit was posted for the expert.
Who are you?
My right, I am appearing at this point of time for the brothers. But my prayer is for the substitution. if the substitution will allow it.
Without an application for
Then,
substitution.
this observation may be given
No,
because,
no, no, no.
my lord, because the court will say that the application has been allowed, the order 1 rule 10 application will not be taken into consideration because it is a joint tenancy. My lord, my only prayer, let, if this application is disposed of, if in future I will file order 1 rule 10 application.
In future, you will file that
I will definitely use. But my lord, the court will say, because the substitution has been disposed of, I will not allow you order 1 rule 10 application.
Let
because
that come,
this is a
then
joint
I will
tenancy.
consider, not
Hello.
now. No liberty. Ashun, this application.
Legal layers of the consent.
Take points. If you are entitled under the law to take that point, you
I'm
take that
grateful.
point. No liberty is necessary. Yes, call the next matter. Yes. Dependent in a suit for eviction. Premises Tenancy Act.
Premises tenancy.
When you will vacate, Mr. Mukherjee.
My defense is struck out.
Nothing
But
remains.
now that blood,
You have a right to cross-examine.
but I did so. Pursuant to my
That
lord's
has also
order,
been done.
your lordship allowed that with a cost of 15,000. Thereafter, my lord, what had happened? My lord, they took out an application for amendment of the plaint. The amendment was, my lord, if your lordship sees, it is, my lord, only, my lord, changing the description of a property in one of the paragraphs. Then, my lord, I took out.
Description means erroneous description has been corrected.
Kindly take it that way. Yes. Now, my lord, I took out a. I not prayed before the court that I should be allowed to file an additional written statement.
that additional written statement was filed. That was a 2-page additional written statement, my lord, which also, my lord, controverted about the misdescription of the tenanted property. Now, my lord, the other side, the plaintiff took out a 151 application to say that in my additional written statement, I have transgressed into other points which I should not have taken there. And they prayed for rejection or non-acceptance of my additional written statement. That is allowed by the learned judge, and I am
Only
before
one
your
thing-
lordship.
only one thing,
Because,
Mr.
Lord,
Mukherjee.
whether well, Lord, I'm sorry,
yes,
Lord,
yes.
yes. No, only my point is that when the learned judge has allowed Lord filing of the additional written statement, the learned judge cannot say that the written statement
The
can.
only question, Mr. Mukherjee, is whether after your defense stood struck off, whether you are entitled to file any defense.
But that was allowed by the learned judge. This is not. I knew that your
27
lordship will ask me this question.
27 suo moto power. I can go into that order also.
Lord, but that is not the subject matter of challenge. But the question here
your
is,
defense has been struck off. You do not have any defense. So how can you take out an additional written statement?
but the additional written statement was taken on record by the learned judge. On their application, Lord, it was struck out.
Because also, yes, so rightly, if some wrong was committed, subsequently the order has been corrected by that.
Whatever my contention in the
reasons
addition.
may be- Mr. Mukherjee, the reasons may be wrong according to you. That can be supplied.
But Lord, my only contention before your lordship, Lord, once a pleading has been accepted by the court, Lord, until unless, Lord, they can show that, Lord, it is
Ordinary case, you have a right to file additional written
Yes.
statement.
Yes.
But in a case where you do not have any defense,
Lordship.
because your defense against delivery of possession,
Yes.
so that is gone. So only you can challenge notice point and other things because your scope of challenge is very, very limited.
That is, Lord, taken in the additional written statement. If your lordship kindly sees that, I have taken that point, Lord, in the additional written statement.
Statement that cannot be only without that, because when a defense is struck off, you do not have any pleadings. So even without that, that basic concept that no evidence beyond pleadings, that goes, because you can only challenge, demolish their case on certain limited aspects.
Lordship.
So that is even without your defense, because your defense is not there. So
But
for that,
I would, Lord, this is my humble submission before your lordship, that, Lord, written statement to that extent, Lord, of the amended plan, Lord, that should be allowed to be retained on record.
can it be done when you do not have your defense? What is additional?
Because, Lord, I am saying that they are trying to
order 8 rule 9.
Lordship. Yes, subsequent. Yes.
Concept is order 8 rule 9. Two things. One is by an order of the court. One is you have a right.
Lordship.
So if it is by an order of the court, no leave is necessary. As in this case, if the plaintiff is allowed to amend his plaint, you have to be given an opportunity to file an additional written statement. That is order 8 rule 9.
Lordship.
And if you on your own want to file a subsequent pleading, that has to be by way of a leave. So here now, what is a subsequent? Once you use the word expression subsequent, there has to be existence of some previous pleading. There is no previous pleading.
But here the learned judge will not relied upon order 6 rule 16 to say that, Lord, that striking out pleading which is unnecessary.
Striking of pleading.
All that I say is, Lord, that it should be restricted to, Lord, controverting the statement which has been amended. Nothing more. I don't want, Lord, the learned judge to consider
Can
the
you
other portion.
controvert when your right under 7.3 has gone? Because your defense, what is the stage of the suit
Otherwise,
now?
the
Argument,
suit is
my
not
argument is over. My argument is over. It's their arguments.
But that will also be over, Lord, in a day.
20th
No, that's
that will
what
be.
is the order under challenge? What is the order under challenge?
Lord, your lordship will kindly come to the order dated, Lord, 16th of December 2025.
Yes.
Lord, will kindly come to, Lord, the last page. Given such fact, the defendant could not have come up with the additional written statement, taking the plea that are beyond the limited scope of the amended portion. The judgment relied upon by the plaintiff appears relevant in the given set of facts. Here, it must be kept in mind that the provision of Section 7.3 WBPT Act is in operation and is
But
not
only
incumbent
one
upon.
thing, reason is correct, Mr. Mukherjee.
My lord.
Here it must be kept in mind that the provision of Section 7.3 is in operation and is not incumbent upon this court to consider the written statement or for that matter the additional written statement. That reason is correct. That has also been stated
It will
here.
kindly
Maybe some additional reasons has been assigned which may not be according to you.
To which my answer will be, my lord, will it not, my lord? I am asking this question to myself, not amount to, my lord, admission by non-traverse. Because, my lord, even if the defense is struck off, my lord, going by, my lord, the Kamakha Singh Dev, my lord, the judgment, the modular India, I cannot cross-examine. But that
No, you can
doesn't mean
cross-examine.
I can cross-examine to the extent of, my lord, disproving the plaintiff's case.
Yes.
But, my lord, I cannot put forward my evidences. But, my lord, moment, my lord, there is an amendment on record and I do not traverse that, my lord, there might be a question about admission by non-traverse. So that question has to be, my lord, taken care of by the learned judge. So, my lord, my additional written statement is all about traversing, my lord, the amended portion, which is at only paragraph 6.
Right to traverse, Mr. Mukherjee, if you take it in that sense,
Lordship,
when your written statement has gone, your right to traverse has gone. So, if you take in that sense, so it's an admission in that sense. So, entire case has been admitted. If you take your submission to that height, so the original plaint case has been is non-traversed. It's not a case of non-traversing because for that you have been given a right to cross-examine. You can cross-examine.
Right to cross-examine is, my lord, disproving the, my lord, the plaintiff's case.
Because that also is limited. You can demolish the notice point and also
all the technicalities on which, my lord, they might succeed, I can put a question, my lord, in cross-examination.
Yes.
But I cannot forward, my lord, my case in defense.
So if that is gone, and what is the purpose? Purpose is to defend your possession. That right is taken away by 7th. Because your defense against delivery of possession is gone.
Tomorrow, if it is found that, my lord, the plaintiff is unable to prove her case in this case, but in that event, my lord, that I do not want that the court to come up with, my lord, that you did not file the written statement and controvert the statement about.
It's a case. It's a case where you file the written statement, but due to operation of law, your written statement was struck out. Because otherwise, Mr. Mukherjee, otherwise it would be a decree would follow. He need not have been also to prove his case by way of evidence. It's not that. Even if you, because as in ex parte, Mr. Mukherjee, you are aware, take a case of a ex parte decree. There you do not appear, you do not file your written statement. So, doctrine of non-traverse, automatically he will not get a decree because he has to prove his case by way of evidence. So, doctrine of non-traverse do not automatically result in a decree in his favor. So, this cannot also inure to your aid, come to your aid. Because even ex parte, we are taking a higher case than that. He chose not to appear. So, if your argument is to be accepted, then they did not adduce any evidence. Plain case, I have said I am the owner, I require this. Let us take a case of reasonable requirement as well as default. Default is also there because 7C default, all right. No written statement. Uncontroverted, I need not produce any evidence, straight away decree. But that's not the case. The law is otherwise, and you have seen many suits which have even been dismissed on ex parte.
Yes, that's true.
So
she has also to prove her case.
So he has to prove. It's not though Order 8 Rule 5 is there, but even that there is a language, Mr. Mukherjee, you are aware. So the court may call upon to prove. Order 8 Rule 5.
Yes. Specific denial.
Yes.
Every
allegation. Specific denial. Next, proviso. Require any fact so admitted to be proved otherwise than by way of admission. Here lies that. So it's not the admission which by itself gives right to a right to decree. So court may say that is why it's to be proved by way of evidence.
Lordship. But will kindly, Lord, see, Lord, that the court has said that the additional written statement cannot be accepted and hereby rejected. That is.
Although it was contended by the defendant that the plea taken in the additional written statement are nothing but the admission made by the PW1 in the cross-examination, this would not give the defendant any right to include the same? No, I could not follow this. Made by additional written statement and nothing but the admission made by the PW1 in his cross-examination. For the simple defense, if that is so, what he has stated in cross-examination, you wanted to prove that was also not needed. That admission is already there. Cross-examination.
No, that portion, Lord, that cross-examination portion, Lord, I am told that is over.
No. So yeah, it has been recorded. Please see
Yes.
this. Although it was contended by the defendant that the plea taken in the additional written statement, that is your contention,
That is my contention.
are nothing but the admission made by the PW1 in his cross-examination.
Yes.
This would not give the defendant any right to include. So your case is that what he has admitted in cross-examination, you want to include that in additional. That's not needed also.
So that was not a wrong submission which is recorded. There are
That's
two
the
things,
recorded.
Lord, that were taken. One, I said that the description sought to be not incorporated is a wrong description of the tenanted property.
That also
and Lord, the
clarified.
notice point I wanted to take. The notice was not addressed to the joint tenants. That was the
Notice
point.
Mr. Mukherjee, were
But
entitled
permit
to
me to take those in an argument.
No, if you have you raised that in the, unless you have raised
But in
that
the
in the evidence.
initial, Lord, the written statement.
No, in the evidence,
The
have you
notices, Lord, goes to the
cross-examined him on that point? If you have not cross-examined him, arguments, you cannot take that point.
cross-examination complete হয়ে গেছে।
আর্গুমেন্ট আমাদের আর্গুমেন্ট হয়ে গেছে our argument is over.
আসুন। Yes, call the fixed matter.
Lordship, there are 4 points that my learned senior friend has taken during the hearing of the. Yes, not yet completed. Hey, complete.
They have completed. Mr. Bhattacharya started
yes.
thereafter.
4 points that they have taken, your lordship. First being,
Which is your matter? Item number? This will continue. This will continue.
why is it not?
बोले दिन बोले
Lord, item 33, which was the next matter, it pertains to, my lord, a child who is 8 years old, but extremely sensitive. Can it please retain its position, my lord, for tomorrow?
Retain its position.
Great.
Sir, what point in this last? First, yesterday, the matter was taken up according to when my property was sealed, well, or despite paying the amount.
It will come up tomorrow. Yes.
And
yes.
Yes. So 4 points that my learned senior friend has taken. First being that there been no status quo. The order of status quo ante could not have been passed by the impugned order. The second point being the impugned order is not illegal. In the application we have pleaded unreasonability, not illegality. Third point, administrative law principles cannot be imported into civil procedural law. And the fourth being, status quo order not varied. So status quo, the order which has the impugned order, the order was not varied. So these are my 4 points, your lordship. So before that, if your lordship kindly sees, there is also a point touched upon by my learned senior friend, that the conduct of the advocates in conducting the proceeding. Since there were 2 dates taken in the procedure between 15 December to 10th of June.
It's not against directed against the advocates. It's the parties.
Parties.
Conduct
of the parties. Your lordship,
nothing against personally against the advocates.
Parties. It is the parties. Your lordship, with that,
because you are creature of instructions.
Your lordship, I would
nothing personally against you.
No. Your lordship, I would just show a list of dates that it's just on its way. Your lordship, the matter, the order of stay was initially passed in 19th November 2022. This is an appeal of 2022. So if I really need to see how the proceedings have carried on, the water would not have been flown so long if my learned senior friend's land would have been a bit of vociferous and a bit of diligent in proceeding the matter. I would just show that, because from 19th November 2022 till 9th January 2025, unfortunately, it was at the instance of the petitioner that time was taken. Hearing happened on 2 to 3 dates. But from 19th November 2022 to 9th January 2025, there were 5-6 dates where time was taken or adjournment was taken on whatsoever ground by the respondent, because there I was the appellant. And moreover, your lordship, from 9th January 2025 till 15 December 2025, there was no order expressly. In fact, your lordship, during that interim period, we came before your lordship when your lordship was sitting in 227 jurisdiction. When there was the interim order expired in June, we came before your lordship and your lordship remanded the matter, directing us to file an application and seek necessary prayers before the learned court below. The learned was rejected. We came back to this High Court under 227. Then, by the order of 15 December, the order was restored. I'm led by Mr. Bhattacharya.
Want to take over?
If your lordship permits, with your lordship's leave, of course.
Yes.
I'm sorry, Milord.
So Bhattacharya, busy councils are to be
Kindly do
have
not
to be
embarrass.
engaged.
Kindly,
Have to be engaged in different courts.
kindly do not embarrass. The difficulty is when matters are not called, the matters are not called. When matters are called, two matters are called at the same time.
It's not a question of embarrassment. So it's a question.
No. I am not, as busy as a lot of other people. It's just an incidental thing. It is very unfortunate, that I was here.
Incidentally for today only. It happened.
No, incidentally for
only for today it happened that two matters are being called on.
Your lordship has forgotten your lordship's days here, Milord. Your lordship had the Milord.
I was not that busy like.
No. Kindly do not, Milord, put these things, Milord. Kindly do not embarrass, Milord. We know, Milord, who was what. At least, Milord, we have also spent, Milord, 25 years here.
Starts.
Yes.
We have to understand one thing. Whenever he is doing matter, he is losing one. That is the.
হয়েছে বাবা বলবো now my lord, what is the issue before you? First thing is, before I open anything else, my lord, the last time the matter was taken up, when there was the court rising and the court matter could not be taken up. That was subject to correction on Friday. Last. The matter was fixed at 3. The matter could not be reached. If I am not mistaken, that was 10th. Now on the 13th, on the 13th of on the 30th of June to the 30th June.
But আমার কাছে পরে এসেছে due date 15.
Milord, on the 30th of June, which was received by us, Milord, yesterday, Milord, they have raised another fresh demand over the self-same property for the period 1st June to 30th June. The rent. And we have paid the rent, Milord. Evincing payment, this document is there.
No, Mr. Bhattacharya, I'm not going into.
No, Milord, why? It is just to show your lordship, Milord. Ultimately, Milord, there is no default insofar as we are concerned over the subject premises. Kindly also visualize that this is only the gate. That portion is the property in occupation or property in dispute. There is no other. The other portions which were in occupation have been surrendered. This is the gate which is only the trouble.
No, the gate, thereafter some property is there.
No, that's ours.
Admittedly, that's ours.
That's ours. This part is government.
No, I could not follow this.
This portion, this gate thing, and whatever the land here, it is just, today as per the schedule. I'll just show.
No, Mr. Bhattacharya, what is the property in dispute in respect of which an eviction order has been passed?
Just give 2 minutes.
Because this is against an order of eviction.
Yes.
So, where is the order of eviction?
Please see. Please see. I'll just show your lordship. This is the portion in dispute.
HL 201.
The portion in dispute, the schedule will show HL 201. This is.
Which page, Mr. Bhattacharya?
This is 2189.
Well, lordship will find that clearly at page 25.
25.
Notice to. Notice to.
Yes. 26 and 25.
Yes.
HL 201 is the only dispute issue.
Yes. So HL.
All that piece and parcel about 121.79 square meters.
Yes.
This is the only thing today.
Yes.
It is bounded on north side by private property belonging to Vijayashree, on the south by private property belonging to Vijayashree. On the east by SMPK's land and used as road, on the west by private property belonging to Vijayashree. So it is only SMPL road which is carrying the goods vehicles, the whatever our vehicles for entry and exit into our own property. This is the road, SMPL road, through this gate. Enter north, south, everywhere, it is Vijayashree's property. That is the sum and substance. Today we are only concerned with HL201. There is no other property which is in dispute. And if your lordship sees page 87,
the last part.
87. Now please come to page 87 for a moment.
Yes.
23/5/2022.
Yes.
In view of the discussions made above, has my lord very kindly got it, it is my considered view that a sum of rupees this, etc., etc., and plot is HL201, or not plot, plate HL201. That is the only issue for the period from this to this. So this is the subject matter of the entire dispute.
Yes.
Now, we have for your lordship, we have prepared the my lordship to Devan.
Yes.
Please see, after this, 19th November 2022, the order your lordship will please to find at page 91.
Yes.
Matter was heard, interim order of stay granted in favor of the petitioner. Such interim position continue. Now, my lord, my learned friend correctly, let us say, my lord, since he is appearing for a Article 12 respondent, though in a civil division, but an Article 12 authority, it is deemed that whatever submission he is making to court is on instructions. He has made a submission that, my lord, in the month of January, in between January and July, adjournments were taken, right? But, my lord, from the list of dates, your lordship will be pleased to find that on 20th September 2023, the Port Authority requested adjournment. On 2nd February 24, the Port Authority requested for an adjournment. 21st September 2024, none appears for the Port Authorities. Then, my lord, 29 January 2025, the presiding officer in the court below was absent. Then, my lord, that was the day when the interim order got vacated. Then 3rd June, the authority files for fresh wakalatnama. Eventually, the case is adjourned. Then, my lord, the matter was heard. The Port Authority requested an adjournment on 9 September 2025. We requested an adjournment on 9 December 2025 because your lordship will recall, since there was no interim order, we had to rush to your lordship's court twice. First is, my lord relegated the matter back to them for an independent assessment of the entire scheme of things. That order passed by the authorities, apropos your lordship's order, is dated, my lord, 10th of September 2025 in Miss Appeal number 161/2022. That order is at page 100 of the papers. 100. Now, my lord, then the matter was, this order, page 100 order, was again carried in revision. And, my lord, on the 13th of December 2025, 13th December 2025, yes, 13th December 2025, this Honorable Court in the revisional application directed, my lord, continuance of an interim order till a particular period, which according to us was X date, according to them was Y date. Admittedly, there was an extension application which was filed on the 16th. I am indicating it to your lordship. The extension, the date when the matter was fixed The court was not available. The court was not available. And, my lord, that date was 12th of May 2026 when the matter was posted for 17 June 2026. Now, 12th of May, since the PO was on leave, the matter could not be taken. Now, my lord, on the 17th, we file an application before the learned court below, seeking extension, pointing out that on the 16th we have been, that there's a padlock. My lord, the learned court below, rightly, wrongly, without, my lord, if your lordship recalls, since my lord was also in that determination at the material point of time, in the morning, the matter was heard, the matter was adjourned. In the afternoon, my lord, I had brought to your lordship's notice the extension order, the order of status quo, which by way of, by producing it in hand, by hand, my lord, and thereafter, my lord, when the matter was thereafter taken up by my lord, your lordship felt that status quo as on 17th would mean the padlock status quo. So you have to take steps there. I mean, not an advice, my lord, your lordship wanted me to withdraw, lest, my lord, any observation made by your lordship in the writ petition affects my case there. I took out an application pointing out about the overzealousness of the respondent authority, I mean the port, SMPL. That persuaded the learned court below to weigh the balance. My lord, it is first submission to your lordship is, apart from anything else, your lordship is not, the court was not weighing between two private entities. It is not X versus Y. Here, it is a special proceeding, a special act, and he is not acting in some other capacity. He is persona designata. If your lordship recalls, my lord, that is what your lordship taught us, my lord, while the matter was being heard. He was a persona designata. In terms of the Act, in terms of the PP Act, Public Premises Eviction of Unauthorized Occupants Act, he is a person who is vested with a power to hear an appeal arising out of that proceeding. It is not, my lord, something as a matter of choice. It's a matter of course. It's a statutory appeal. And, my lord, a statutory appeal was being heard by him. Inter se one public entity vis-a-vis one private entity, assailing whose order? Assailing an order of the estate officer, again a creature of statute. Now, my lord, why I am saying this? Because a lot of deliberations and submissions have been made across the bar regarding the language employed by the learned court below while deciding the matter. Now, my lord, without meaning any disrespect to anyone, my lord, reasonableness and fairness in action is an inherent part of any jurisprudence. It is an inherent part. My lord, natural justice is imbibed in every proceeding. Otherwise, my lord, when your lordship ordinarily hears any matter sitting in this jurisdiction, ordinarily in the absence of caveat, your lordship desires a notice to be served. Only in what cases ordinarily your lordship doesn't, perhaps, my lord, in expeditious hearing matters. That too, if the dates are very long and everything. Otherwise, ordinarily, a representation is insisted. So, my lord, that very essence today flows from, my lord, the jurisprudence which we know as administrative. Here, my lord, the learned court below has imported certain, my lord, certain principles, if I may say so, to nullify the action committed. Now, my lord, a submission has been made that the status quo, whatever status, it could not have been annulled. Reliance has been placed on judgments which shall come. But prima facie, my lord, kindly I request your lordship to kindly, my lord, for the present, this is arising out of a proceeding under a special act, where summary proceedings are insisted before the estate officer. The estate officer, in terms of the act, has certain contours on the basis of which he has to hear it. He is not what, my lord, an ordinarily civil judge, my lord, while hearing a suit does, an eviction suit at that, or any other suit at that. Here he is within the contours of the act. And within that contours of the act, he has passed an order which has been assailed in appeal, and an interim order was subsisting from the day it was passed till 16th. Why I say so? Because status quo as regards my possession, irrespective whether the interim order was subsisting or whether the interim order was not there, the status quo as regards my possession continued till 16th of June 2026. When, my lord, I put this question to myself, had it been an Article 226 court, my lord, perhaps plenary powers are available with your lordship to call for the file who has instructed this padlock. It is not on statutory authority, cannot act unilaterally. It has to be on someone's note that someone has approved it. That a matter is coming up on the 17th and you put a padlock on the 16th. This sort of a action, this sort of overzealousness, I could have understood that on the 10th of January or in January 2025, when the interim order for whosoever's mistake, I take it, my lord, there is a mistake. I have told my learned friends, there is no doubt about it. But, my lord, again, with greatest of respect, from January 25 till June 2026, they did not put any padlock, or they did not try to, my lord, put the proceeding or render the proceeding into a nullity. Because they know that that is the only place through which my vehicles enter. And there is, again, why I invited, my lord, though your lordship is not going into it, 100%, your lordship is correct that your lordship need not go into it. But this document also evinces that there is no, the long chain of payment, there is no gap. We have been consistently paying the rent. Whether, my lord, from 16th of June, some overzealous officer of SMPL, suddenly, my lord, it dawned on him that a padlock has to be put. And, my lord, there was it has to be. It cannot be someone goes and puts the padlock. I could have understood it's a private entrepreneur. It is SMPL. SMPL goes and does it, it is impossible. It has to be on someone's advice, someone's note, someone's instructions. So that padlock was put. Now the order under challenges, the court felt that this moving to such overzealousness, stepping into such an action, when admittedly the proceeding is coming up on the next day, is grossly violative. It is in the light of, it has been couched to be an unreasonable act, unfair act, and the court has proceeded to deal with the matter. My learned friend says, correctly says, I take it, correctly says, relying on usual principles as to whether that is permissible. My lord, the judgment cited by him at the bar, those deal, first of all, those do not deal with any PP Act case. Those do not deal with such a situation where thing has been done when tomorrow the injunction application is coming up for hearing. I do or I step into an action seeking to undo the injunction application. It does not deal with such a case. My lord, yes, again I repeat, there have been days. My lord, let us take it from January to December, there was no interim order in 2025. They did not take any action. They did not take any action. What was the roving urgency that when a matter is coming up on the 17th, you seek to undertake an action on the 16th? I'm going to please see the order now.
Yes.
And first, I invite your lordship straightway to the order under challenge.
Yes.
Please come to the order under challenge. And first, before that, it is my duty, my lord, first to show your lordship, my lord, this honorable court's order at page 68, 19th August 2025 order.
Yes.
Passed in CO 2950 of 25.
Yes. Page?
My lord, 68.
Yes.
This application under Article 227.
This was for 5 months.
No. This was not for 5 months. This was at a stage there was, kindly see the second part.
Yes.
This application is at the instance of the appellant in misappeal this and is directed against an order dated June 3, 20 passed by the learned additional district judge FTC Howrah. The learned senior advocate.
Which page?
Page 68.
Oh, 68.
Kindly seize, Miller.
Yes.
The learned senior advocate appearing for the petitioner submits that an interim order of stay of operation of the order passed by the estate officer was passed by the learned judge of the appellate court on 19/11/2022. He submits that the said interim order was extended from time to time. He further submits that through oversight, the petitioner could not take steps for extension of the interim order on 29/1/2025. When, Milord, as per my instruction, the PO was absent, for which the order stood vacated. He further submits the petitioner filed an application for extension of the interim order. Immediately thereafter, he further submits that the petitioner also filed supplementing for reimposition of the interim order. He submits that the learned judge of the appellate court be directed to hear out the said application. Will not hear out the said application and I'm sorry. Just give me 2 minutes. Hear out the said application and just give me. Sorry, Miller. Miller, hear out the said application. Application for extension. Order sought and proposed to be passed. There is no necessity to issue notice upon the opposite behalf. The learned advocate appearing for the petitioner shall be obliged to forward a copy of this application along with this order upon the opposite party or upon the learned advocates representing them before the appellate court. From the order sheets appended to this revisional application, this court finds that August 28 is fixed for hearing of the petition on dated June 3, 2025 and for filing objection. In view, CO such and such stands disposed of by requesting the learned additional district judge to take up the hearing of the petition dated this, etc. And ultimately the matter was relegated there. Then, my lord, the order passed in this is page 100.
Yes.
My lord, 10/9/2025. This is the petition of June 3, 2025. My lord, I do not know, my lord, how good a copy your lordship is having. The order ultimately reads that the supplementary are considered and rejection. It is rejected on contest, which prompted me to come once again by way of revision, and ultimately the interim order was reimposed. This is how the interim order was reimposed. I put this question to myself, my lord, when the interim order was reimposed, there was no overt or covert action at their instance. So therefore, nothing troubled them. They did not, on this reimposition, they did not travel anywhere from that reimposed interim order. They accepted the reimposed interim order and accepted the situation to continue. Their problem is, my instructing advocate had some medical issues, and on 2 occasions he had prayed for some leave not to assist the court. One day, only one day. That becomes so problematic that when the PO was on leave on the 12th of May 2026, when the interim order, according to whosoever's calculation, was subsisting, this was not pointed out. What was pointed out is the matter comes up as per the 12th order. It comes up for consideration on the 17th. It is possible, that a put-up could have been given or some application could have been filed to prepone the date or for reimposition of the interim order. That step, I cannot say it should not have been taken. But having regard to the entire chain of circumstances, it was for whatever reasons not taken. On the 17th, an application was filed because that was the returnable date, indicating that this is the factual position insofar as padlock issue. The learned judge, for whatever reasons, felt that the status quo, as was imposed previously, should be permitted to continue without batting an eyelid. Without batting an eyelid, that the status quo by that time had changed. Now, my lord, that was on 17th. 17th order, ultimately, my lord, we take out an application for reimposition on the 23rd.
Or for modification.
Or for modification. For modification. Bringing it to the notice that this is the factual position, this is something must have prevented your honor from taking into consideration this factual aspect. Kindly do something. They used their written objection to that, right? They filed their written objection. The matter was hard, and ultimately this is the order passed. Now, my lord, kindly now takes the trouble to come to the order under challenge.
Yes.
Now, please see. Now, these orders become significant. Page 108. 108.
Please tell the internal page number.
Yes, that internal page number 108, annexure N.
No, I've got the order. Improved order 1st of July.
Yeah, 1st of July is the last order.
Yes, you want me to go through that order?
Yes, yes. There is the order under challenge in the revision and application.
Which internal page of that order you want to place?
No, please come. Now, please see. Actually, everything is discussed.
Yes.
It is discussed here. Now, please see internal page. This will be 3.
Yes.
This is their submission before the learned court below. Learned advocate for the respondent had also strenuously argued.
It did not travel to the submission part. Kindly straight away come to the finding.
Yes. Here, please see the same page. From it is somewhere in the middle of page. I have perused the record and it appears.
Yes.
that on 16/6 there was indeed no order of stay or any order directing the parties to maintain status quo. Only such could not have been a reason for the estate officer to act with such unexplained sense of urgency. The estate officer must have had knowledge that the court was scrutinizing the legality and correctness of the order as passed, and such scrutiny had reached the penultimate stage. Each and every order passed by any authority should not only be legal, but also be reasonable and adhering to all notions and pillars of natural justice. The order or any action of any authority should not only be within the contours of law, but in each and every such action, due reasonability must be imbibed. Many a times the litigants approach the court seeking an opportunity to bring specific order of stay from the higher forum, and the court does not stand pleased to grant one opportunity to such litigant to bring specific order of stay. If such orders are not brought forth, there stands no further hindrance to proceed in accordance with such law. Such a single opportunity should have been given by the estate officer, and especially where an order of the Honorable High Court of Calcutta is subsisting that provided the appellant the liberty to renew the prayer for status quo. The heavens would not have come crashing down if the estate officer would have provided an opportunity to the appellant to bring forth any order of stay prior to putting the padlock. The instant appeal is of the year 2022, and there has been intermittent periods where there was no order of status quo or order of stay, but no such act was committed by the estate officer. The action of any authority should conform to the theory of legality and intertwine with such the theory of reasonability. Such a concept is evolved with such blood. They have relied on Wednesbury Corporation. I also speak that an action by an authority can be within the contours of the statute, but still struck down as unreasonable. A lot of emphasis has been made. To this sentence while making submissions. While the question, this last part of this, while the question, did the authority have the legal power to do this? Might be answered in the affirmative. The question, did the authority exercise that power in a fair and logical way? Putting, a question to myself, why was this question put? Because the court below, I am not, in the armchairs of the court below. I do not know what weight with the court below. But, presumably, the court below had this notion in mind that it is looking at two parties, one of which, incidentally, is not a private party. It is a government entity. And this is a special act. This is a special act. This is not a normal legislation.
Yes.
Now, keeping this in mind, this is the nature of the order which has been passed. With greatest of humility, my learned friend, if I am not mistaken, has relied on 1992 SCC 117. Then 2008 8 SCC 348. Then 2006 3 SCC 312. To that, we have our answers,
How much time it will take?
Tomorrow, anytime.
How much time?
But keeps it at 4 o'clock. No, if the matter is taken up, I have no problem.
How much time it will take?
Maximum these judgments has to be distinguished, and we shall be citing half an hour maximum, 45 minutes maximum.
45.
We are at the receiving end because of their unilateral action.
Unilateral.
And I'm sure, that Mr. Nag was not taken into confidence before initiating this action. I don't think, he being a very reasonable person would have advised this.
He will not make any comment now.
Huh?
He will not make any comment now for this. You are instigating him. He will not make any comment.
Well, he has become cleverer by the day, after sitting in the small room. Sitting with giants. I do not have the opportunity. I sit in the long tables or benches.
Giant doesn't sit with giants.
I sit on the benches without a fan. We have ordered. We have all pulled in money. This air cooler is yet to come.
Air cooler.
পরশু ছুটি হচ্ছে তো No. There's a letter. There's a letter. জানে না যাচ্ছে? Lotus Club has given us. Let us be lordship keeps it to subject to the business of the court permitting, of course. 3:45. No, I think 3:45 would mean 4 o'clock.
So, Bhattacharya, the only difficulty is the motions, because today I also could not touch some of the motions. That's the difficulty.
Can it be? তুই আর বাড়ি ফাড়ি যাবো না নাকি?
কি বলবে বলো তো?
I don't think. One way or the other, it will be adjourned. Let me take a chance tomorrow at 4 o'clock. Kindly.
কালকে কি আছে? Keep it at 4, but subject to that, if that continues, that might not be taken up. Please keep a watch on that.
Only this, we'll keep a watch, definitely.
As soon as that is over, I will come. I am ready.
Perhaps it is understood that after the bench disperses, your lordship is going to sit singly again. That is the.
That I do not.
As I know your lordship, perhaps your lordship would.
Number 35, what is this? Expeditious. Din to 35.
Great.
35 file ta din. 35, 18.
Proposal of the injunction application, my lord.
This application under Article 227 of